Oh, you're not on interim. It was is to be considered after appearance of the respondent, but it has not been considered till date. So you're not on interim. It's not. You must take a delay by 28th of April.
May it please your lordship, I beg to mention item number 7. I am for the respondent. I seek an adjournment for this day as my senior counsel's B. Chakraborty's father is in critical condition. So my humble prayer before your lordship is that kindly fix the matter after Bihu.
It's okay. Whether you have informed the other side.
I will inform now.
So I am appearing for the respondent, school respondent. My lord, they seek the time, my lord, because it is question of maintenance, area maintenance of the children. So only the question is that whether it is should be given from the date of application or from the date of the order. So his landed senior says he's out of station. So let it be fixed any appropriate date. My lord. Can it be fixed on the 2nd of the April, 2nd April?
No, her father is in critical condition.
Critical condition.
If 2nd April possible, then we can fix it. No issue. Will it be okay for you?
ICU does.
He is in ICU.
Yes, he is in ICU.
Then let it.
Then better to take after Bihu, I think.
Yes, sir. Okay. Okay, your lordship. Can it be fixed on 21st?
Yes, can.
21st, sir.
21st of it.
Okay, your lordship.
And the
Deeply obliged to you, Lord.
List matter on 21 court.
May please, Lordship. I wish to mention item number 9, Lordship. I have taken possession from the underside, Lordship. Finally, adjourned for today, Lordship.
You are for whom?
I am for the petitioner, Lordship.
You are for the petitioner. You are Mr. Mujumdar?
Yes, not. I am on behalf of Mr. AMS Mujumdar.
Your good name?
M. Hussain.
M. Hussain.
Yes, Lordship.
Heard Mr. M. Hussain appearing on behalf of Mr. AMS Mujumdar. And with the consent of the other side, prayed for an adjournment. Prayer allowed. 27th of April will do.
Here is an interim order, Lordship.
Interim is there. Interim will continue till next date of listing. We are listing it on 27th of April.
May I please, your lordship? Lordship, I beg to mention for listing of the DA, lordship.
Make
Actually,
a mention before court number 8.
yes, lordship. Actually, what happened, lordship? Earlier, lordship, this Friday, lordship, arising out of the same FIR, lordship, 10 others were granted bail, lordship, without the case diary, lordship. So now, if it is listed this week, lordship, ours is
No,
only.
I am not listing. You may make
lordship,
a
already
mention or
mentioned.
approach before they raised it so that it can be listed, or make a mention before court number 8.
Lordship, actually, it's in the bail hearing stage. That's
No, whatever. We are not
lordship.
listing it. We are not taking any mention slips,
Lordship.
and we are not listing it.
Okay.
You make a mention before either before court number 8 or approach directly before raised. That
Lordship.
will be accommodated.
Obliged.
May it please your lordship. I beg to mention item 28, lordship.
20.
28, lordship.
Yes.
Humble-
What is the position of 28?
Lordship, humble prayer for adjournment for the matter today, lordship. Senior is not in Gauhati, lordship.
Who is your senior?
Lordship, Anand Kumar Bhuya and Swarna Bhuya.
Anand Kumar Bhuyan. You are on 28.
Yes, lordship. Mayuri Bhuya.
Is there any interim? What happened? No, scan copy is all right. Is there any interim? The request made by learning council appearing on behalf of MSM Bhuya, the learning council for the petition. Matter is adjourned. However, the scan copy of the PCL has already been received. 1st of April will do.
Lordship. Lordship, date.
1/4. 1st of April.
Oh, lordship. Okay. Highly obliged, lordship.
May I please, your lordship?
Yes.
Well, here the petitioner before your lordship is a medical practitioner having MBBS and degree with diploma in maternal health. Page 15, on the basis of page 15 FIR, my lord. On 13, he was arrested. For a moment, Your Lordship, kindly page 15 is the FIR.
Yes.
May I read?
Mm.
With due respect, I beg to state that I am a permanent resident of the above mentioned address. On 12/3 at about 3 p.m., while I went out from my house after having lunch, I show that the above name accused, Dr. Parthasarathi Acharya, along with a lady and a youth, came with a white-colored four-wheeler and stopped nearby the national highway. The woman had with her a newborn baby. Thereafter, the trio started going towards the house of Sahadev. Thus, I saw a dao and knife in their hand. I know Dr. Parthasarathi as I saw him often visiting the house of Sahadev Das. Sahadev Das and his wife were not at home when Acharji and his two associates went to their house. The accused stayed at the house of Sahadev Das for about 10 minutes and returned back. At the time of returning back, the newborn baby was not with them. Besides me, some other people of our village also witnessed the incident. The accused returned back with their vehicle. I suspect that the accused killed the newborn baby and buried the dead body somewhere in the backside of the house of Sahadev Das. So this is the allegation FIR, my lord. On the basis of this FIR, the petitioner was arrested on 13, my lord, and he was produced before the learned Chief Judicial Magistrate Huzai on 14. Where from, my lord? Your Lordship will kindly page 19. These are the reason for his arrest, my lord. 14. My lord, got it, my lord.
At page 19.
Page 19 is are the grounds of his arrest. First 1, 2, and 3
Yes.
are relevant so far the present petitioner is concerned. They accuse Acharji after delivery of the baby was not reported the police CWC, that is Child Welfare Committee. The mother of the baby refused to took the baby. It is clearly indicate that Acharji broke the section 105 BNS. Baby was premature born. He need proper treatment, and as a doctor, Acharji know that, but still Acharji not provide the proper treatment to the newborn baby and gave the baby to his nurse Priyanka Das for take care of the baby who don't have any degree of nursing. It is totally shown his negligence. Acharji, it is clearly know that at that situation when after a baby born, if their parent refused to took the baby at the time, he has the duty to inform the police or child welfare committee or government hospital. So these are the allegations, madam. So on 14, he was produced before the Chief Judicial Magistrate, and police took 2 days remand, prayed for 4 days remand. Your Lordship will find the first remand application is at page 21. For 4 reasons, citing the 4 grounds, the police sought 4 days remand. The learned CGM allowed 2 days remand. Thereafter, on 16, after completion of 2 days police remand, he was again produced before the court. Then again, page 22, your Lordship will find, he was another application for further 2 days remand was sought for. The learned CGM has allowed 1 day. So these are basically document could not be seized. These are the ground. So document could not be collected because I am not the owner of the clinic. I am sitting here, my lord. I am just a patient. I am not the owner. So 3 days police remand, my lord, subjected to, my lord, detail and thorough police investigation. I am a doctor, my lord, not a professional, my lord, culprit, my lord.
No, where is the baby gone?
And your Lordship, kindly consider one thing, my lord.
Where is the baby gone now?
Baby died. Baby died on the very day because and my fault is that I do admit, my lord. This is my fault that instead of admitting police, I took the responsibility to bury the baby. On good faith, that was done, my lord. Because
Buried the baby.
that was procedural negligence. I do admit, my lord.
Every
But the-
negligence is there.
Yes,
Not only the profession.
extreme negligence is there. my
Your
lord. I do
That
admit,
time
my
You took the baby to the house of
Yes,
Sahadev and then
Your
you
lordship
did
may-
all these things. And now you are sitting there.
that I have done.
Your lordship may
You
kindly
buried the
peruse.
baby also.
Your lordship may kindly.
Yeah, my
peruse-
lord, my humble submission is that, my lord. I am not a professional.
You are a professional killer now.
Now, my lord, the question is, my lord,
Your newborn
negligence.
baby, You not spare a newborn
At the-
baby also,
if
and now
at
you're
all,
saying that you are not.
although I am not admitted
You
because,
may be a doctor, so what?
so my humble submission,
may
was
be a
3
doctor.
days
In
police
human
remand,
law, you
everything has
done
been
these
seized.
things.
Everything
Be
has been seized.
irresponsible and irresponsible. You
That-
buried the
yes.
baby also.
Yes.
Yes.
Your lordship may kindly come to my lord, page 5, paragraph 6 regarding his explanation. A couple came to his chamber, my lord, a pregnant lady there, one my lord child born, my lord. Thereafter, my lord, he my lord trying to project that thereafter the couple fled away from the chamber, my lord. Without intimating a police, my lord, he tried to that some of his friends tried to adopt that baby. So while he went there to hand over that baby, ultimately that baby died, my lord. This
That
is his, my lord.
all these
explanation.
things are there, my
Can it
lord.
be accepted, my lord? And whether from the, my lord, grounds of arrest, my lord, being a doctor, my lord, can it be, my lord, said that he has not committed the offense, my lord?
No, yes, my lord.
Yes, exactly.
Therefore, I have led your lordship to page
Your
number
lordship may
19.
kindly
Extremely, that
peruse
is, that what is done
paragraph-
is, it is
Para6 of
happened, my lord.
petition, my lord, his petition, my lord.
Yes, that I have,
Last
this is the incident that I have categorically stated, because I have not concealed anything, what happened. I do commit mistake, my lord, because I did not inform the police. Yes, I admit, I am not, it was my duty to inform the police. But on good faith, what is happened, it is happened, my lord. My humble submission is that, my lord, 3 days repeated police demand, initially 2 days.
And now he
Truly
said that he buried the, my lord, baby, my lord, without intimating anyone.
Yeah, that is there, man. But intention is never.
At this
105 is the main offense,
CJ
my
may
lord.
be called for.
Earlier 304 part 2, my lord. And my humble submission is that, my lord, if at all the allegation is, my lord, what I have said, my lord, it is 304A earlier, now 106. My humble submission, my lord, CD will reveal these things, my lord. I do admit there is nothing, my lord, to conceal, my lord. I do admit, yes, the baby was, I took birth the baby at my clinic, my lord. It is an also admitted fact that the parent of the baby fled away. It was abandoned. And the allegation your lordship is 19 your lordship has seen, my lord. So, my lord, what is there in my lord there? But the question is that 3 days, my lord, investigation period custody required for investigation only, my lord. Interrogation. That has been done, my lord. Twice custody taken, my lord. Twice police remand, my lord. I am a doctor, my lord. And I have no criminal past antecedent, my lord. And categorically, I have stated in my petition. So, considering all these
Earlier
things, my
also
lord,
doing all these things, but it
I
did
am
not
ready
come,
to, my lord,
to the light
abide
of
by
the
any
public.
condition, my lord. I am ready to abide by.
Earlier also you might have done these things, but it
Yes,
does not
yes,
come into the
yes.
light of the public. But
Yes,
now
yes.
it has come. That is it.
My lord,
Anyway, we are calling for the case.
On 6th of April, my lord, 6/4.
6th of April.
election,
Will do.
before, my lord, can it be on next Monday?
2nd of April, my lord.
Next
Okay,
Monday,
then 2nd of April.
Second.
Next Monday is not.
next Monday,
Next Monday is which date? 30.
30 on 30.
30, is it possible? Will come.
Well, Lanka from Lanka.
Prime
We'll
30
try.
or 30.
Otherwise, election
Okay, then.
time, my lord.
What comes again, he will be in difficult. 2 would be, my lord, convenient. 2
First
second.
or second would be better, I think, because if it doesn't come, then again,
Second.
let it be on 2nd of April then.
Otherwise, my lord, I am admitting that there is negligence is there, my lord. That part I cannot deny right now. On second, my lord,
Oh, 2nd.
I am of that.
May I please, your lordship? Lordship, 482 application, lordship, and the case is registered under section 316 of subsection 5 of BNS, lordship. And FIR, lordship, will find page 9, lordship. At 11 page, lordship, page 11, lordship.
Yes.
The lordship allegation is that, lordship, the manager, lordship, received complaints from certain bank accounts holder, lordship, uh, alleging that Lordship unauthorized debit transaction and cash withdrawal from their account without their knowledge and consent, Lordship. And the petitioner, Lordship, he is the senior customer service assistant at Central Bank. Point number 3, Lordship, that during preliminary investigation, we observed suspected cash withdrawal in 5 savings account amounting to 1,29,000, Lordship, of various customers on different dates by Sri Nairi Gupta. And subsequently, Lordship, he was suspended from the said bank, Lordship, on 26/11/2025.
Though you are the customer, you say your custom, what is say your?
Lordship,
You
senior customer service assistant, Lordship.
Oh, senior customer services.
Lordship. Lordship, I have stated in paragraph 4, Lordship, kindly, Lordship, page 4, Lordship, paragraph 4, kindly, Lordship, page.
Yes.
Your Lordship may kindly come to that. It has also been observed. That is, the FIR has been lodged after, my lord, receiving complaints from the customers, my lord. And that it has also been observed from the account records of Mr. Narit Sengupta, the present petitioner, that cash amounting to rupees 5,027,5,02,785 was deposited in cash in the salary account number so and so, other than regular salary credit during the period July 24 to December 25, height 51 entries on various dates. Cash deposited from source other than salary is not justified by him. Not only one, my lord, total 51 entries, my lord, not in his salary account. But those amounts, my lord, from the earlier allegation that those amounts were transferred from the savings account of the complainants.
So basically, he is the prime accused.
He is the prime.
Allegation is against him, Lordship, and I have stated in paragraph 4, Lordship. He was already
Not
suspended.
only once, my lord, total 51 times, 51 entries.
It is here submitted, it is reasonably apprehended
Lordship.
that taking advantage of said circumstances, certain transactions were carried out through the petitioner's login credentials without his knowledge and consent.
Lordship.
Can it be possible? How? Because it is your account and some accounts where there, which is just can be considered as suspicious transactions.
Lordship.
Not only once or twice, but 51 transactions are there.
Lordship.
Let the city be called for, we'll see to it, what is there. In this
Lordship.
case, because you are the prime accused.
Lordship.
It's not that against you, you were maybe one of the officials of the bank, so you may have some apprehension. It's not that. Cases, entered cases against, basically against you that
Lord-
you did this.
Lordship, there only one accused, Lordship, is there.
Only one accused.
Only one
So it is
accused.
you. Let the city be called for, we'll see to it.
Lordship. In the meantime, Lordship, protection may be granted.
Protection cannot be given. Yes,
On 6th of April, 6.
6 will do. Oh,
Lord.
6.
If you allow, Lordship.
City be called.
May I please, your lord? This is an application under section 482, my lord, and the FIR is at page number 19,
Yes, 19.
my lord. May I read, my lord?
Mm.
The FIR has been received from one Dilip Dhar, so and so, alleging commission of serious financial and criminal irregularities by certain bank officials during the financial year 2023 in sanctioning personal loans, wherein an internal investigation revealed that the concerned officials, namely Juridas Kaur, Mofidul Hussain and Mrilal Das, while posted at SBI Mirza branch at the material time, appraised and sanctioned multiple personal loans in gross violation
This
of
case we
extent.
have
Yes,
already
yes, you
called
have seen-
for the case diary. When?
Yes.
When it
yes.
speaks?
No, other two petitions,
Other
your
two-
lordship, after perusal of the case, your lordship was pleased to dispose of
Dis-
that.
But most probably, so far I can remember, most probably this is the Mohidul who was
Uh,
not only working as a field officer, but as a thing.
Service-
He is service
because-
manager.
Service manager,
service
manager.
manager. So as per the allegation by the other accused persons, and if I have to control the case record.
Yes, ma'am.
So he is the only person. Entire that relevant period, he was in dual charge.
Yes, ma'am. Yes.
So entire thing is there. So we just call for the case diary.
My lord, interim protection may be granted, my lord.
Here, no, we have used the case record against him. The entire allegations is brought.
Yes, my lord, out of the 34 accounts which were alleged in the FIR, 10 of the accounts has already been closed and others they are repaying. There is no pecuniary loss, my lord. There is no pecuniary loss as alleged in the FIR. 10 of them have already been closed, my lord. That's why I'm
Yes,
praying for
got it.
interim protection, my lord.
He is saying
Pecuniary
that there is no
loss,
pecuniary
Pecuniary
loss.
loss is more than rupees 1.5 crore. ma'am.
Yes,
And-
it is going on, my lord. They are closing the EMIs, my lord, regularly doing. If a court prices might, I can
We can
give
give
the
you a short
records,
date because as per the CD which
Yes,
had
yes.
revealed or earlier, what little I can remember from
yes,
that.
my lord.
Yes,
One-
yes, I have
Yes,
seen this.
yes, my
So he was the only person who was dealing in both the charges.
Yes.
my lord.
So during
Anand-
the entire period of
Yes,
that
my lord.
misappropriation.
One
so
co-accused was also there. Co-accused Rafiqul Islam was also named there, who was working as service manager, not exact. He's there. The accounts are dealt by him, and 10 of them has already closed, my lord. That's why I pray for interim protection, my lord. What did maybe claim?
On 6, I can produce.
he is not on interim, let it be on 1st of April then,
Yes, my lord.
1st of April. Because we're not going to give any interim for it.
Oh, yes, ma'am.
1st of April, CDB call for. By that time, we will produce the case diary. In the meantime, most probably there are some progress in the investigation as you have submitted that 10 accounts has already been
yes, my
closed
lord.
and all. So let us see whether there is any recovery and because otherwise the pecuniary loss is more than 1.5 crores. That is the loss.
And they are paying, my lord. The 30 other 24 accounts, they are regularly paying, my lord. I
We'll
can
see
appraise the
then.
court,
Okay,
my
then.
lord.
1/4 we are listing it on 1st of April. Short date we are giving as soon that can be possible. CDB.
Applies, my lord.
May I please, your lordship?
Yes.
This is a pre-arrest bail application, lordship. I am not a named FIR named accused, lordship. FIR is a page 8 translated copy.
Hmm.
May I read, lordship?
Yes.
With due respect, my submission is that on 22/8/25, I came to know that rupees 29,000 was credited in the bank account of Rahul Alam, alias Firdaus Alam. The above mentioned accused persons together are committing cybercrime. The accused persons together by making forged Aadhaar card and PAN card are extorting lakhs and lakhs of rupees through online. Meantime, all the accused persons together extorted rupees 90 lakhs. The above named accused persons has begun doing such cybercrime since long. I am not the named FIR named accused. Suddenly, police on the last week came to my house and searched me in connection with this case, lordship. I am no way
Why
involved.
they have searched you? I mean, why they have searched you? You are same Mofidul of item number 3.
No, lordship.
Item number 4, my lord.
No, 4 is also Mofidul's, 3 is also Mofidul. Same person or
Yes, yes.
Huh?
The name is same, my lord.
person is not same?
This is Lahori Ghat PS 20.
This is different. Lahori Ghat, lordship. Item 3 is
So
a
why
Mofidul
now
sec-
why you are apprehending or why you have apprehension?
Police is searching me, lordship. Recently,
what?
on the last week, police came to my house in connection with this case
Ah.
and tried to ask my parents about whereabouts of me that I am involved. I am no way involved, lordship, in any crime. And this affair has been filed by one private person, not even police, lordship. Not even police. By a private person, he heard something.
So how you are related with those the accused?
I am no
person?
way related, lordship.
You belong to which district?
I am nowhere related.
Sorry, Morigaon is okay.
Three
But
are
your village is Goroimadi.
three are named accused and others, my lord.
So CD may be called for, lordship, and in the meantime, interim protection may kindly be granted. I am ready to cooperate with the investigation, lordship. I am a
One is
petty
also from Goroimadi, that is Aminul Islam. Who is he?
neighbor, lordship.
Yes, Bhattaku, got to say.
Otherwise, my lord, although their name is not there in the FIR, my
And
lord,
FIR is of 25
and my lord,
9,
it
Lord.
is not required to lodge FIR by police or anybody. FIR can be lodged by any private person or anyone, my lord.
This is an
But what are the offense what he has committed, my lord? By preparing, my lord, fake Aadhaar card, PAN card, my lord, through online, these are involved in committing all these cyber frauds. So, my lord, at this stage, my lord, my prayer
F-
before lordship CD may be called for without, my lord.
FIR is at
any
90,
interim
FIR is of 1909, Lordship.
These are serious
So I am
type of
ready to
offenses.
cooperate with Lordship, interim protection. If anything comes, my prayer may be rejected, Lordship, on that day also, Lordship. So that I can appear, give my statement to the police.
Without, my lord, custodial interrogation, those monies will not be recovered. my
This
lord.
is cyber,
He was-
90 lakhs
90 lakh.
money has been
Let the CD
29
come.
lakhs.
Till CD I may be protected.
No, my lord, at this stage, my lord.
His name is not there, but I don't know in others, their name is and others.
Yes, yes. 2nd of April, my lord, I can produce the CD.
I will not abscond, Lordship. I am a local man, Lordship. No chance. If anything comes against me, Lordship will be at liberty to cancel my bail, Lordship, on that day also, Lordship.
Ultimately, my lord, although his name is not there, the FIR, if FIR comes, he will be the main, my lord, culprit, maybe the.
Hard Mr. S.K. Potter, Delaney Council for Deputy. Hard Mr. B. Bhattaku, Delaney additional PP, April. Statute. It's an application under section so and so in connection with so and so. Next, submitted by Mr. Potter that the present accused present petitioner is innocent and is no way connected in the alleged offense. From the FIR itself, it is seen that the basically names of 3 persons are there who stated to be committed crime, cyber crime by misappropriating rupees 29 lakhs from the bank account of his present petition. But the police is visiting his house as he is the neighbor of one of the accused persons and searching for him, for which he filed the present petition seeking pre-arrest bail. But he is ready and willing to extend his cooperation in the further investigation of this case if he is granted with some information. Mr. Bhattaku, the learned additional PP raised objection and submitted that this is a cyber crime wherein rupees 929 lakhs has been credited in the bank account of the above named the 3 accused persons, and from the FI itself it is seen that some other persons are also involved in the alleged offense, and hence without perusal of the case diary he is not in a position to submit he is not in a position to say as to how the present petitioner is involved in the alleged offense. So, accordingly, Mr. Bhattaku insisted to call for hearing this submission, we fell under and only considering the fact that the present accused petitioner is not an abandoned accused. Let some interim protection be provided to the present petitioner till receipt. We give it some interim protection when it can.
My lord, on 22nd of April.
22nd.
Yes. 22nd. Okay, you'll be under interim protection 22nd.
Obliged, Lordship.
Yes, fine.
May I please, my lord? My lord, the petitioner before lordship is a contractor. From the year 2020 to 23, he has executed the work of repairing of my lord water supply system, my lord. In 2025, the FIR lodged, my lord. FIR is at page 17, my lord. May I read?
Yes.
With due respect, I beg to inform you that TS Enterprise, proprietorship of Tafizul Islam Hazarika, had received contracts for 2 schemes under the Public Health Engineering Department, Sibsagar, the Khelua Water Supply Scheme and Nopam Borwati Zone 1 scheme. The proprietor Tafizul Islam Hazarika used fake pipes in all these schemes. Furthermore, all the CIPET certificates required for these pipes were completely fake and forged and submitted to the Department Authority Public Health Engineering Department. The department authorities at that time, Alokes Kakoti, SHE, Ajay Lahon, then my lord Tapan Fukan, Rajan Fukan, currently retired, released the bills completely without any investigation. Even after the fake and false CIPTs were brought to the attention of the department officers, they released the full bills through collusion with the contractor to benefit unfairly. Moreover, in the above mentioned scheme, fake pump test certificates were provided and pump bills were released without connecting new pumps. On the other hand, according to PHE guidelines, pipes should ideally be 3 feet deep, but in these schemes, pipes were laid within 3 inches to 8 inches of depth, and in some places left on the ground without being put in. Therefore, despite knowing about the above mentioned document forgery and irregularities in contract work, the said officers released the bills and misused government funds for their own gain. Hence, their actions are punishable by law. Lordship may kindly come to page 23, my lord. My lord, with regard to allegation of use of fake pipe, my lord, this is a email, my lord, issued by CIPT. This is a Government of India enterprise, my lord. The email says, my lord, with reference to the subject and letter referred above, this is to inform you that the documents and CIPT inspection reports submitted in respect of the work order scheme and contractor mentioned in your communication have been verified with the records available at this office, and the details contained therein have been found matching and consistent with the available documents. Then, my lord, may come to next page 24, my lord. This is, my lord, issued by Executive Engineer Sipsagar, my lord. It says about the authenticity of the pipes and the documents submitted, my lord. And my lord, in 2024, similar complaints were made. And my lord, then one inspection was carried on. That is at inspection report is at page 26, my lord. Page 26, my lord, here the FIR is with regard to, my lord, number 1 and number 2, my lord. May I read, my lord? The first one is my lord, it was inspection committee. It is report, my lord, 20 inspection was carried on 26/10/2024 and 27/10/2024. My lord, inspection committee consists of, my lord, the persons, all the names are there, my lord. Number 1 is Khelwa PWSS. This is the project, the allegations are made, my lord. The committee has visited the Khelwa PWSS along with TPI officials, concerned SO and SDO. Moreover, Jal Mitra of the scheme, President and Secretary of WUC, concerned contractor and some of the beneficiaries are present during the inspection. All the issues mentioned in the RTI are inspected thoroughly and following observations are found thereof. Pipeline depth have been checked at 5 random places, and the depth of the UPVC pipe is found to be about 250 mm to 300 mm. The pipelines are laid over the embankment of Water Resource Department, where they have not allowed to exhibit more than 300 mm as per the concerned AEE. Regarding branding of pipe, the branding and company name as well as batch number are not visible on the pipe as it was laid over years ago. Therefore, no conclusion to be made. During the inspection, it has been seen that one centrifugal pump and one open well pump was present at the site. The specification of the centrifugal pump were not mentioned on the pump. According to the Jal Mitra, the previously installed centrifugal pump was replaced by the contractor due to some mechanical error. The final bill of PWSS submitted. Then, well, second one, also the inspection report almost of same. So my submission is that, my lord, earlier also complaints were made, my lord, and my lord, this FIR was lodged by one of the worker of, my lord, Krisak Mukti Sangram Samiti, although he has not disclosed. And my lord, the petitioner is a contractor, my lord. He has executed the contract and it was completed in 2023. 2025 FIR was lodged, my lord. And although in 2024, same complaint, my lord, and the inspection was carried on, my lord. And my lord, the CPIT already certified that the documents submitted are already, my lord, genuine documents.
Otherwise, from the, my lord, contents of the detailed investigation of the matter will be required by the whether regarding already they have received their bills, my lord, after execution of the works regarding
As per the FIR, they have received their bills.
yes. But regarding those, my lord, pipes which were fake or the detailed investigation would be required, my lord. Will be
Departments were equivalent and petition, so departments will be for the done additional PP being on status board and applications, so and so in connection with specs. Next one. Is submitted by Mr. Gupta, the Iran counsel for the petition. The petition is directed by profession and he had completed that safe project of your FRE was at which?
My lord, FIR is at page 16, 16.
Relevant portion from page
Relevant will be 17, my lord.
Ah, yes.
17.
Yes. Completed this safe project of water supply. Kelua, KHELUA, Kelua Water Supply Scheme. And the he did last pastoral and he did completed the scheme in the year 2023. And earlier also on the basis of that complaint, one inspection and committee was constituted and they have inspected the project and project. Thereafter, only with some malified intention, the FIR has been lodged in the year 2025 after 2 years of the completion of the said project. Further, he submitted, though it is alleged that some fake pipelines of CIPET was used, but from the annexures filed along with the present petitions, which has been issued by the one executive engineer as well as the department concerned, certifying the authentication of those pipelines which were installed in the said project. However, the petitioner is still ready and willing to extend his cooperation in the further investigation of this case if he is granted with some interim protection. Mr. Portakur, Ilana, additional PP submitted in this regard that project has already been completed and they have the bills were also been cleared where some allegation of fake pipelines were allegation of installation of fake pipelines were brought in the FIR. Accordingly, Mr. Portakur insisted to call for his diary to know the actual facts. Considering this submission made by Landing Council for both sides and all other aspects of the case, and also considering the annexures filed along with the petition, this court is of opinion that sub-interim protection may be provided to the present petitioner to receive case time. Okay, will be under interim protection. When it can be?
on my lord 30th of April 304.
Obliged.
Date of it.
Obliged.
What is position of 20?
20 my lord CD not received. Petitioner is in interim.
None appears on call for the petitioner. They did not receive. Issue reminder. Entry be continued till next request. Yes, when it can be next time.
On 23/4
23.
22.
Yes, what is 22?
22 my lord report received my lord. I have
Report received.
yes.
Is there any case?
My lord.
Ah.
My lord, no report received.
No report received.
Yes, report not yet received, my lord. regarding whether any case pending against accused Ziaul Karim Ahmed.
20 Lupa Lipa, a non-appear to call for the petition.
Oh,
Where it is submitted by Mr. Watt that
Good.
no report is received from the concerned police station. I wait for the issue reminder. Please the matter accordingly on.
Mati.
7-4, 6-4 will do.
Yes, 6 for me.
6-4. So and so interim be continued till next day.
May I please, my lord? My lord, I'm sorry to say, my lord, item 20, my lord.
Yes, you are not there.
I don't-
20 remain unrepresented.
Yes, my lord.
Yeah, already order has already been passed.
This search sheet, I think this file search sheet, lordship. This search sheet file.
We have extending your interim till 23-4.
Okay. Deeply obliged.
May I please, Your Lordship?
Yes.
The earlier given CD was called for my lord. Petitioner not in interim my lord.
Yes, Pothakku, what is the position?
23 CD received money.
CDDC. Okay, very nice.
FIR space number 14. Vernacular.
1-4.
Lordship. Petitioner before your lordship.
23 my lord, informant is also there. Man.
Hmm?
PM report not
Oh,
yet
acha, acha,
received.
informant is also there.
Lordship. This is not a POXO
Who is
case, my lord.
appealing for informant?
Yes.
Informant names of 1,
Last occasion appeared, my lord.
3, 4. 4 petitions are there for informant. Can they be informed? We're keeping for some time otherwise.
After some time. man.
After some, we'll try to inform the others.
Otherwise, if they not appeared, then I will point out to your lordship. না লাগে তথাপি তো নামটো আছে
নাজানো খবৰ দি চাওঁ যদি আহে নাহে শুনি লওঁ নাহে টাইম দিম চুইচ কৰোঁ তেনেকে আহিবতে আহিছোঁ তেতিয়াহ'লে পিছবেলাই হ'ব 2টা বজাতে ঠিক আপুনি কোনটো বাচ্চা Yes, what is the position of 25?
25 my lord case diary not received money.
They are not on interim, I think, no? Oh, is it? No, Nunmati.
Non Mati, yes. Earlier one report was called for my lord. Later on report received that one case is pending against the present petitioner Nunmati PS case number 41/26.
Ah.
Thereafter my lord CD was called for on 13/3/26.
Oh, acha. But they were not on interim, I think.
Yes.
Interim was not there, I think.
Interim was not there.
None appears on call for the petitioner. CD not received. Issue reminder. It's the matter accordingly when it can be listed.
On my lord 7th of April.
7. CD.
26.
May I please? Lordship,
Yes.
the report was called for by
Yes,
incident.
let us see. Yes,
my
is
lord,
there any report?
Not yet received. My lord, your lordship may kindly take out after some time. My lord, probably I will get the amount.
Aman,
Do you have any problem? After time being or?
rest of time.
Pardon?
Ruta was that.
At 2.
At 2? Okay.
My lord, kindly pass over the matter for time being.
Oh,
Obliged.
Other report received, no
what kind of report?
any case pending registered
okay,
against the
yes.
present case persons.
We have received the report.
Yes, your lordship. Lordship, my
Case is
senior,
pending against you.
Lordship, my senior will argue this matter, Lordship. Kindly pass over the matter.
Is there anything to argue? You have filed one petition saying that maybe case may be there, and it is now reported that no case is pending.
Yes.
Okay, then he is.
No case pending
Okay,
against
okay, thank you.
both the petitioners, Malord, Shakti Kumar and Akshay Kumar.
Not Shakti Kapoor. Okay, we'll wait. Okay.
Here also, my lord, a report was filed, Lord.
Report.
Yes.
Case is pending or not.
Yes, Malord.
Yes, we have received any report?
Yes, from the report received, my lord, the investigation is going on, my lord. One.
On the basis of one GD entry.
Very entry, my lord. Here on it.
Critical report.
See, considering your submission, we provided you some interim.
Yes, my
protection.
lord, I have appeared.
But in spite of that, you have not appeared.
Yes, I have appeared, my lord.
But report says you have not never appeared.
So, my lord, I have appeared.
Appearing,
and I was-
you have called for several times, but you did not appear, never appear.
No, my lord,
So
I have
why did
appeared
it
and
happen?
police has informed me that my statement was not recorded, my lord.
Ah.
I was only informed that we are waiting for medical report. Thereafter, we will decide any case will be registered or not.
No, but by that time, but when you are called by the police, why you have not appeared?
Because, my lord, I was apprehending arrest, my lord. And
You are given a course, interim protection was
yes,
given
my lord,
to
I
you.
have appeared. I have appeared, my lord. I have appeared, but my statement
This
was
report
not.
is of 23 and the order was passed on 10-3, but you have not appeared. If your conduct will be done, then in that case, we'll vacate your interim.
My lord, I have appeared. As per instruction, I have appeared. And it was
The
informed
report
to
says
me.
that you
Yes.
never appeared.
Well, let him file an additional affidavit.
Yes, my lord, I will.
Otherwise, my lord, let him appear within a period of 7 days if not yet appeared, my lord. Otherwise,
Heard Mr. H.Ali, the learned counsel for the petition. So heard Mr. P. Botaku, the learned additional PP, appearing on behalf of state respondent. Till that, as per the police report, till that there is no case has been registered against the present petitioner. But on the basis of the GD entry, the inquiry was GD entry number 22 dated 15/02/2026. The inquiry is still going on. And till that, even after several reminders, the petitioner did not appear before the police station. But on the other hand, on the other hand, this submitted by Mr. Ali that his petitioner had already appeared before the IO as and when he was called for after providing him the interim protection. In view of this, later detailed report be called for from the police station on the next date of listing. In the meantime, the petitioner will file an additional affidavit stating as to when he appeared before the police station. And further, if not appeared till date, the petitioner is hereby directed to appear before the police station within 7 days from the date of order. The interim be continued till next date of listing. Also call for a detailed report from the concerned station. List, no matter when it can be.
my lord, on 2nd of April.
Second.
Oblige.
Yes, what is the position of?
Well,
30?
CD was called for, my lord.
Party, my lord, case diary not received.
Well, this is the second day charge sheet, CD has not come. My lord, a similar case, my lord, my name is not in the affair. co-accused has been having name in the FIR has been granted bail by the Honorable High Court, my lord. My lord, the allegation is that his son went to the fishing pond and my lord, he was chased by them, but next day, my lord, his dead body was found drowning in this pond, my lord, and dead body was recovered.
We'll call for the case diary.
Yes.
CD not received, issue reminder. Give a short date so that it can
On my lord, 1st of April.
first of April. Yes.
My lord, kindly keep an eye. If CD won't come, interim shall be considered, my lord, kindly. Because
not
of
to
the
make
election,
such-
I am a doubt whether the police are able to
Better
come.
Better not to make such observation, otherwise we are giving you short date as far as practical.
Development.
27, finding item.
I'm extremely sorry, my lord, when the item was called, my lord, I couldn't take it. My lord, that a report was called from the Jalukbari police station because we are apprehending that one, what is the name? TL Rajkumar.
You have received the report.
Yes. কি বলি এটা আমাকে কপি করুন
Till date against you, no case is registered. Case is registered against one Shakti Kumar and Akshay Kumar.
I am Shakti Kumar.
Huh?
I am Shakti Kumar.
Oh, you are Shakti Kumar. Acha, Bhattakur, he is Shakti Kumar.
Yes, Sakti Kumar and there is no case pending against both the petitioners.
Oh, no case pending?
No case pending.
Oh, sorry.
I was taken by surprise.
Acha, no case is pending or registered against you.
Against.
That is Shakti Kumar and Akshay Kumar. You are not the Akshay Kumar.
I am Shakti Kumar and Akshay Kumar.
Shakti Kumar and Akshay Kumar?
Yes,
Oh, both the are-
petitioners.
Father and son.
Two petitioners. One is Sakti Kumar and one is.
Mani, your family is the filmy family.
Filmi, acha.
Filmy background family. Anyway, till that we don't have any case.
My lord, in that instruction may be recorded, my lord, and my lord, subject to what your lordship says, an observation that needless to mention that in case if they file, then notice under 35(3) will be issued.
My lord,
No,
not
that
yet
is-
required.
We cannot say what nature of case will be registered.
No,
It may be a case for 35(3). It may not be a case of 35(3). We cannot say.
If it is not a case of 35(3), nothing, my lord, I have got nothing to say. But because this, I have specifically mentioned that my apprehension is regarding some financial transaction.
Anyway, that cannot be a perception. Anyway, heard Mr. M. Biswas, 27. The Learned Counsel for the petition also heard Mr. P. Bhattakur. The Learned additional PPA bring on state respondent. Report received from officer in charge Jalukbari PS, whereby it is stated that no case has been pending or registered against the present two petitioners, namely Shakti Kumar and Akshay Kumar in the said police station. In view of this, the present application is hereby disposed of. Disposed of, however, with a direction, and with a direction, and the interim granted to the present petitioner dated 5/3/2026 is hereby stands vacated. However, the petitioners are at liberty to approach the appropriate forum in case any registration of this, in case of any registration of the case against it in the concerned station. With the above observation, yeah, it's keep the report along with the case.
I'm replying.
I said. Mr. Bhattakur, we have already given notice on 23, item number 23.
Yes.
Because if you see in item number 22, the same counsel was there for the petitioner.
Yes.
Most probably he is not present today. I don't.
Then also, well, I will point out whatever the materials in the CD, well, and
Yes,
PM
and-
report. Otherwise, not necessary that informant already
Not
named shown in the
necessary,
cause list.
that's
If they
right.
have not appeared,
Ah.
well,
23 can be called.
Yes.
23.
Oh, he left, I think. He left. Okay. then. We'll get that.
35.
Yes.
In this case, your lordship granted interim protection me, and accordingly I appeared and I had recorded my statement, madam. The allegation is that, madam, I have assaulted her husband, but that is as per his affair, my lord, where your lordship has granted me bail. But the affair that I have lost, my lord, against Diganta Dole, who has raped my minor daughter, my lord, and a case under section of rape as well as the POCSO has been registered against him, and it was the public who took him to the police station by assaulting, my lord, for committing such heinous crime.
Otherwise, case is
Yes.
registered under which section?
Yes, pardon?
Against you, what is the section registered?
Against me, my lord, 318, 109, 127, 137. And wrongful
118
confinement,
also there.
punishment for kidnapping. I have not kidnapped my husband. Public has taken him to the police station, my lord. Then voluntarily causing grievous hurt. Public has assaulted him for committing a minor girl rape, my lord. My daughter was raped. You see my position, my lord, in that.
In the cross case which you have registered,
My
your
lord,
daughter
that-
has been raped.
Yes, my daughter has been raped. I have appeared, I have recorded my, I have cooperated with the investigation.
And the victim statement, lordship, it will be clear, my lord, regarding cross case also, my lord. Victim statement, my lord.
Whose statement
Lord,
is?
victim, my lord.
Victim.
Not the victim, my lord. Here is the who was assaulted, my lord. That in this way, he is the victim. Present case. What happened with him? Dikonta Dole.
Reason behind that is that I think.
My lord, there is a cross case, my lord, against him. Those allegations are there, my lord. But in the present case, my lord, all the accused person taken in a bullet, my lord, to the another place, my lord. There he was assaulted, my lord.
Public is
But-
assaulted, my lord, causing this heinous crime.
Of kidnapping but assaulted.
But assaulted. Medical report are also there, my lord. In the last page, my lord.
Yes, yes, I have. seen.
My lord, that is there, my lord. And after entering his appeared, my lord, statement.
How many accused persons I get? Only one.
Two, my lord. Two, my lord. Perhaps she is the wife. Wife.
Pardon?
Wife, my wife.
Ah, yes, wife.
Wife.
ওনার বেলই দিয়ে নেয় ওনার বেল হনে যথেষ্ট ভিতরে আছে
Administrative
এই দলে দিগন্ত দলে
and also heard.
পক্সো তার এগেইনস্ট তো
Bishop.
এইটু কেস মানে accused দিগন্ত দলে against whom he was still in jail because the POCSO is there.
Whatever, maybe that is the
Yes.
defined. Yes. And charge sheet submitted in this.
That our case is first 41725 is our case. Their case is 418 subsequent case, madam.
So and so.
Rashid,
And
no, how about
disseminate
it?
and same connection between subsidiary receipt with the same. Next, submitted by Mr. Chris, representative
Minor
partners, and they have not committed any such misconduct here. Await
I took the box over, you know.
committing rape on their minor daughter, even crime, and some general property subject to
তিন বছর হবো।
the informant that a party from such. And for rape of their minor daughter, they have already instituted a case which has already been charged.
Declare missing comment.
And the informant is still in.
80.
Next, but after obtaining the order of interim bail, the petitioners have already acted. And their statements have got record and they extend cooperation according. So, next, but Mr. Sharma, the learned additional PPs that day after obtaining the order of interim bail, both the petitions have appeared and cooperated with the investigation. However, as per the medical report reveals that the victim sustained injury on this person, and there is also allegation of kidnapping and assault against these two petitions. Next, but hearing this submission made by learned counsel of both sides, considering the materials in the case diary and the conduct of the accused petitions, I find that custodial interrogation of the petitioners may not be necessary at this stage for the purpose of investigation. In view of this 40th of April, this is the final. So it is 1912. Huh? Absolute was 9. Okay, you will grant it. No, absolute.
Deplorable.
Petitioners.
23.
My lord, case diary received, my lord, PM report not yet received, my lord. FIR is at
It's 14. Page 14 is the vernacular. Petitioner before your lordship, FIR accused number 3, 4, 5, and 6.
3, 4, 5, and 6.
5 and 6. Father, mother, and uncles of the prime accused, my lord.
What is your case?
The So far as present petitioners are concerned, my lord, the allegation is that 1 নং আসামীৰ সকলো ধৰণৰ কুকাৰ্যত 2 নং আসামীয়ে সহায় সহযোগ কৰি আছিল আজিৰ পৰা 6 মাহ মান আগত মোৰ ছোৱালীয়ে উপায়হীন হৈ 1 নং আসামীৰ উক্ত কুকাৰ্যৰ কথা ঘৰত কোৱাত মই 3, 4, 5, 6 আৰু 7 নং আসামীৰ আগত উক্ত ঘটনাৰ বিচাৰ খোজাত আসামীসকলে ওলোটাই মোক গালিগালাজ পাৰিছিল আৰু এই বুলি ভয় ভাবুকি দিছিল যে প্ৰয়োজনত মোৰ ছোৱালীক 1 নং আসামীৰ হতুৱাই বেলেগ মানুহৰ লগত দেহ ব্যৱসায়ত জড়িত কৰাব বুলি প্ৰকাশ কৰে. That's the allegation against the present petitioners, my lord. In fact, petitioner's house about 30 kilometers away from the informant's house and the place of occurrence, my lord. Victim girl committed suicide in the next door of her own house, my lord.
Otherwise, my lord, PM report not yet received. Whether this is a case of suicide or murder, my lord, at this point of time, it cannot be said. My lord, dead body, yes, dead body was recovered in the house of one Ayub Khan, my lord. That on the day of the incident occurred on my lord 21/1/2026, and on the day of the incident, there was no one in the house of the Ayub Khan. My lord, here main allegation against Zahidul Islam, accused number 1 and 2. And before the incident, my lord, there is love relation between Zahidul Islam and my lord, the victim
Victim.
deceased. And on the day of before the day of the incident, my lord, there was altercation between them. And at that point of time, accused number was also there, my lord. And my lord, there are allegations that my lord, the present accused persons, my lord, he has my lord some photographs, my lord, during their while they were in love, my lord, and she, my lord, on the pretext of my lord violating those photographs, my lord, she committed, my lord, he established physical relationship with the victim, and therefore she was under mental trauma. Later on, my lord, she disclosed everything, my lord, to their family members, and then they came to know about the incident. Then thereafter, the family members went to the residence of the accused and intimate about their affairs, my lord, with the other accused persons, my lord. Then they, my lord, by some words there in the FIR, my lord, they threatened the, my lord, father of the deceased. These are the allegations. And later on, my lord, on the day of the incident, there are statement of the witnesses that and in the house of the Ayub Khan, where, my lord, dead body was recovered in a hanging condition, my lord. There was those accused number 1, 2, and my lord, victim deceased was, my lord, there before the incident. And thereafter, my lord, the neighboring people's statement that they were in altercation with the deceased, my lord. Before the incident, just before the incident, they were there. Now, my lord, without PM report, it cannot be said that this is a case of suicide or murder. Only PM will reveal.
In fact, my lord, one submission, my lord. The incident was took place on 29th January 2026. Allegedly, this is a very serious case, my lord. But FI was lodged on 4/2 after 7 days, my lord. If they had threatened prior to 6 months ago, then they have come prior to that incident, my lord, against me, my lord, against present petitioners, my lord.
Otherwise, my lord, from the materials available in the CD, my lord, main allegation against, my lord, I have found the materials against accused number 1 and 2. But however, my lord, the allegation is that your lordship may kindly peruse the case diary, my lord, FIR, my lord.
আজিৰ পৰা 6 মাহ মান আগত।
Yes.
Pardon is B. Bora, returned counsel for the petition. Also, Mr. P. Watford, United Edition PP, April posted on. I've been an application call for the informant. The names of 3-4 advocates have been shown in the court. Say they received, but this is an application. Section 18, so it's very submitted by MS Bora, the present. Accused petitioners are the accused number 3, 4, 5, and 6, who are not at all connected with the alleged offense. More so, from the plain reading of the FI also, it's seen that the entire allegation is brought against accused number 1 and on the day of incident also, it is stated that there was a quarrel between accused number 1 and the victim. But in the FI, the only allegation brought against the present petitioner is that prior to 6 months of the occurrence, the matter was reported before these 4 petitioners. They misbehaved with the family members of the victim, the informant, and also threatened that she would be engaged in some illegal prostitution, in prostitution or business. But these four petitioners are not at all involved in the alleged offense. However, they are ready and willing to extend their cooperation in the further investigation of this case if they are provided with privilege of pre-arrest. But Mr. Water, the learned detection submitted in history that it is a fact that basically the allegation is brought against the accused number 1 and 2, and on the day of incident also, the petitioner, the victim was seen along with accused number 1 and 2. But the final opinion of the date is not yet received as to whether the victim died for committing as to whether the date was suicidal or homicidal in nature. Considering the submission made by Larry Council for both sides and also considering the materials in the case diary, we find that these four petitions may be provided with protection of privilege, can be provided with privilege of pre-arrest bail, and with a direction to appear for the IO and cooperate in the investigation. In view of this, the present four petitions, so and so will be with. Okay, your pre-arrest bail prayer is considered. Okay. There will be some conditions abided by all.
Okay.
On
Public.
28th of April, 28th.
This was in motion stage.
It is bail hearing.
Bail
Bail
hearing.
hearing.
I have already granted in
Yes.
protection.
Yes.
Public.
Dispose of him.
This
For agrees on item number 6.
Maybe before the ship. My lord,
yes.
this petition is regarding my lord questioning of criminal proceedings, my lord.
Yes.
Initiating, my lord, lordship will see the FIR, my lord, page 13, my lord. This FIR basically has been lodged by the victim father, my lord, respondent number 2. Case was registered under section, my lord, 366A, my lord.
Yes. Yes.
So, my lord, now lordship may kindly note that, my lord, kindly see, note that, my lord. Death of part of the victim is 26/4/2001.
24.
24/6/2001.
Yes.
And the incident occurred on 11/10/2016. And the FIR was lodged on 13/10/16, 2 days thereafter. Therefore, my lord, age of the victim at the time of occurrence will be, my lord, 15 years, 6 months approximately, my lord.
Accused.
Victim.
Victim.
Yes.
Victim will be 1 year,
15 years, 6 months approximately, my lord. To that effect, my lord, supporting documents has been already there on the part of record additional affidavit filed by the victim, my lord. Now, my lord, the marriage was solemnized on 25/6/2019. That is, my lord, annexure, my lord, annexure B, page 18 of the criminal petition, my lord. At the time of marriage, my lord, marriage. Therefore, my lord, at the time of marriage, I, my lord, admittedly, and no, my lord, date of majority will be the 26/4/2019. Date of majority, attaining majority.
24.
26/4/2019.
By the time she was measured.
By that time, my lord, I am already 18 years, 2 months, approximately.
You're for whom?
I am for the petitioner, my lord.
Petitioner is an accused.
Accused.
So these are the ages of accused only.
No, these are the age of victim I'm giving, my lord.
At the time of marriage,
I'm 18 years, 2 months approximately, my lord.
your age.
Victim age. I'm
I'm-
mature, no dispute, my lord. I'm above
No,
mature.
you're saying I am, that's why I'm.
My lord, that's why
The
confusing.
victim, my lord. I'm
There's a
sorry, my lord,
victim,
for
my lord.
clarification, my lord. The
Victim was,
Yes,
Ah.
victim.
victim was 19 years.
18 years, 2 months.
At the time of marriage.
Yes.
Ah.
So, my lord, this FIR, my lord, was in that time filed, my lord, by the informant, my lord, because of some misunderstanding, my lord, between us. And now, my lord, the only problem is that, my lord, since we have already, there was a love affairs between the both of us, my lord, and we have already solemnized our marriage, special marriage act, my lord, and one child is, my lord, already now born, my lord. Date of birth is 12/10/2020, my lord. Now, my lord, the birth certificate, my lord, is here, my lord. Lord, I'm sorry, my lord, I misplaced the file, my lord.
It's okay, whatever your.
Yes,
child
my lord.
wants
Yes, I got it, my lord.
2020.
I'm sorry, my lord. I got it, my lord. I misplaced, my lord.
These are the birth certificate of your child.
Yes, my lord. And the father as well as the, my lord, mother also I have. Now, my lord, so far, my lord, contention, my lord, filing the affidavit, my lordship may kindly also appreciate, my lord. Para 3456 of the affidavit filed by respondent number 2.
Here in this petition is there.
In the, yes, affidavit in opposition filed by respondent number 2.
Para.
Para 3456. That may be not, my lord.
Yes.
That the same has been affirmed, my lord, due to some misunderstanding. There was love affairs between the parties, my lord, and they have already materialized the issue, my lord, by, and now they are living happily, my lord.
Four.
3456, my lord. Now, my lord, on the basis of this honorable court direction, my lord, the victim also, my lord, has filed additional affidavit. Lordship, may kindly see para 678.
Additional.
Victim has filed a additional affidavit, my lord.
The respond number 3.
Yes, my lord. Para 678, my lord.
Yes, sir.
Now,
Not yet completed.
Yes, yes.
therefore, my lord, my humble submission will be broadly on two bases, my lord. First aspects, my lord, lordship may see, my lord, of course, my lord, we have a very, we feel pity, my lord, but it's, since it's an offense once registered, my lord, therefore I'm submitting, my lord, on two broad aspects, my lord. Firstly, my lord, whether, my lord, does 320 earlier, my lord, CRPC, my lord, that, my lord, that has to be read, my lord, along with 482, my lord, should not read in isolation. And power, that section 320 restriction embargo will not come in a play while exercising 482, because this court under 482 is a very ambiguous jurisdiction, my lord. This court is also vested discretionary power, my lord, unfettered jurisdiction, my lord. Therefore, my lord, 482 will come into play, and for the end of justice, my lord, criminal proceeding that has to be quashed, my lord. And the court also, my lord, in some judgment held, my lord, the honorable appeals court, my lord, what for the end of justice, my lord, the court may exercise, my lord, 482, my lord, contrary to the provisions of CRPC, my lord. That was what Supreme Court also held, my lord. I will, my lord. And second aspects, my lord, since the matter already, my lord, is become settled, my lord. So court also says, my lord, in a matter when, my lord, family dispute or matrimonial matter, my lord, is issued, my lord, court must also, my lord, in a situation regarding what genuineness of the, my lord, regarding settlement of genuineness, my lord, court must, my lord, to encourage, my lord. That was the court also, my lord, developed the law, my lord, in hand, my lord. Now, my lord, so, my lord, such once the matter has been,
It
my
was
lord,
registered
settled,
only
my
under
lord.
366A or POXO is also added.
POSCO is also there. That's what I'm submitting, my lord. Technicality should not come, my lord, in a way to, my lord, embark my petition, my lord, for restraining, quashing, my lord. And, my lord, continuance of further proceeding will be, my lord, it will be a futile exercise, my lord, in my humble submission, my lord. And dispute, my lord, once, my lord, since party are living peacefully, my lord, my lord, with heavy life, my lord, that must be more, court may also be, my lord, once the party are, my lord, realize the mistake, my lord, what they have committed in the tender age, my
POXO
lord.
is subsequently added, sir.
My lord.
What POXO? 6 POXO.
Section 4 is there.
I have not seen it. Do you have?
My lord, record I will have to verify.
Section 4 is there, my lord. My lord, lordship may see last annexure of my petition, my lord.
Okay, I'll just
My-
but
Okay.
It's the mistake. And, my lord, repent, my lord. So, my lord, at this stage, my lord, and their desire to, my lord, stay peacefully, my lord, and considering the future prospect, my lord, court may in that situation, my lord, factual situation, my lord, instead of a deterrent approach, my lord, in a corrective measure, my lord, the best solution, my lord, to taking care of the future prospect, my lord, pragmatic view may be, my lord, taken consideration by this court, my lord. And, my lord, since the POSCO Act, my lord, section 2D, my lord, 2D, my lord,
child has been defined, my lord, up to below 18 years, my lord. Therefore, now, my lord, seniority has changed, my lord. Considering the, my lord, this adolescent age, my lord, there grow, my lord, scientifically, my lord, what to say, my lord, it's very, very fast, my lord, growing stage, my lord, therefore development. Therefore, my lord, now the court has, my lord, evolved a concept, my lord, that thus POSCO Act, my lord, is making a suggestion to the legislature, my lord, that this age should be reduced, my lord, and the POSCO Act should be amended, my lord. That was now the court is, my lord, making an observation, my lord, in various judgment, my lord. My lord, lordship is quite aware, my lord, that there's various, my lord, law that has been held by this court, Honorable High Court and the Apex Court, my lord. As your lordship is aware, my lord, I think I should not pardon your lordship relying to judgment, but my lord, for the sake of justice, my lord, at least, my lord, considering those as future prospect, my lord, of the petitioner and the victim, my lord, since there's already, my lord, solemnized their marriage, my lord. That for that, my lord, I'm just relying, my lord, on those sedition, my lord. What the court has held, my lord. Yes. First paragraph, first sedition, my lord. Para 6, my lord, may be relevant, my lord. There are three principles has been, my lord, laid down. When High Court may exercise, my lord, power, my lord. My lord, I'm not, my lord, reading into my lord lordship. I just indicate the relevant paragraph. Lordship may kindly take pen, my lord, to refer to, my lord, while considering this petition, my lord. Next edition, lordship may see the page para 108. Next edition, second number, my lord, and 109. There are 7 conditions has been, my lord, enumerated by the Honorable Apex Court, my lord. Under what circumstances court may also exercise, my lord. 8th condition, 7 condition, and 109 paragraph will also be relevant, my lord. I will not take much time, my lord. I'll just keep on referring, my lord. Third sedition, my lord, lordship C, paragraph 15. Here also, my lord, 10 proposition has been laid down, my lord, by the court. When quashing petition has to be, my lord, considered. Lordship got it? Then, my lord, my lord, serial number 4, my lord. Para 6 to 13, my lord. This is also recent judgment, my lord, 25. Para 6 to 13, my lord. Referring earlier sedition, my lord, earlier to ruling, my lord, the court has laid down, my lord, para 6 to 13. I marked, my lord, I think. Now, relevant, important thing, my lord, that so far that part is concerned, my lord, so far, my lord, 1 to 4 sedition that I have relied, my lord. That so far that part is concerned, my lord, is regarding general principles, my lord. When 482 has to be interfered, my lord. Now, A, my lord, sedition now. So far, my lord, this POSCO Act is concerned, my lord. Now, it will start from A, my lord. Paragraph 12 to 16, my lord. Lordship body. Here, my lord, the court held that courthouse has encouraged, my lord, those, my lord, genuine persons affected by, my lord, victimized by this POSCO Act, my lord, those first victims, my lord, should encourage for settlement, my lord, for genuine person, my lord, when they desire to, my lord, make settlement, my lord. And 320 clause 9, my lord. Now that will be under new act, my lord, 359 clause 9. that will not debar the High Court, my lord, in exercising 482. That was what, my lord, has been held, my lord. That principle has been, ratio has been laid down, my lord. Now, my lord, next citation B, my lord. Paragraph 29, 30, 31, 32, my lord. This also says the same thing, my lord. 320 does not limit the quashing of proceeding, my lord. And technically, this should not be allowed to stand quashing criminal proceeding once compromised. And continuance of criminal proceeding after compromise would be a futile exercise, my lord. That was what held by the court, my lord. In para 29, 30, 31, and 32. Now, my lord, next citation, my lord. C, my lord. C, my lord. Para 15, 23, 29. Here, my lord, para 20 talks about, my lord, section 320, clause 1, my lord. That is, my lord, compoundable section without permission of the court. And section 320, clause 2, my lord, which deals with, my lord, heinous offense, serious offense, which permission of court may be required so as to compromise, my lord, compromise the matter, my lord. And, my lord, section 329, which, my lord, embargo was laid down, my lord. What I was referring, my lord. That has been referred, and 482 will override, my lord. That was first said. And, my lord, for the end of justice, High Court can pass an order in violation of even CRPC. That was what in paragraph 23, my lord, the court has held, my lord. And 320 has to be read, cannot be read in isolation, and has to be read with 482. And accordingly, my lord, considering those aspects, my lord, the criminal petition has been allowed here, my lord, quashing, my lord, 302, 395, 307, 304B, my lord, involving heinous offense, my lord. Now, my lord, next citation, my lord. D, my lord, D. Jitendra Rakhuvashi and others. Para 12, 13, 14, 15, 16, 17. Here, my lord, offense was registered under section 498A 40634, read with section 3, 4 of the Prohibition Act. Here, my lord, issue was relating to matrimonial dispute.
It's okay. Have you given any citation of POCSO related
Yes, my lord.
that come to that?
Yes. Those citations which I rely also deals with POSCO first in the second part, my lord. Now, my lord, kindly jump directly, my lord. E is regarding stage of quashing, my lord. Court.
What is your stage at this stage?
My stage is, my lord, my lord, consideration of judge appearance, my lord. Initial stage, my lord. Para 13, 31 may be relevant, my lord. The court has, my lord, occasion to, my lord, elaborate under in what stages court can interfere, my lord. At the initial stage, my lord, before evidence, court may be reluctant, my lord, slow in interfering. But after charge sheet, my lord, after once evidence, my lord, is started or completed, my lord, court may not interfere. That's what says court. Para 31, my lord. Severance seniority has been laid down, my lord. And, my lord, recently, my lord, to the next judgment F, my lord, the court may held in this case held that any stage of the proceeding court may quash a criminal proceeding. And here, my lord, section 376 was involved in this case, my lord. Para 19, para 22 and para 19 sub para 23 and para 22. Now, Lordship, may kindly come to G, the Madras High Court, my lord. Madras High Court, G, serial number G. Para 10 to 21. My lord, here, my lord, the court also, my lord, is involving my lord POSCO. The victim age was, my lord, beyond, my lord, it was a minor admittedly, my lord, 16 to 18 years age group. Seniority has been, my lord, discussed, my lord. And the court has, my lord, make a suggestion even to the legislature that that those age of the child has to be, my lord, my lord, reduced, my lord, at least to 16 by, my lord, by way of appropriate amendment, my lord. And suggestion has been made, my lord, for such appropriate steps for amendment, my lord. And the court, my lord, this, my lord, future prospects of the child has to be, my lord, of the victim, my lord, to persons, my lord, party in criminal proceeding, my lord, has to be, my lord, taken care of, my lord. And court may, my lord, lenient view may be taken, my lord, when persons, one of the person involved is of, my lord, is of, my lord, tender age, my lord. Referring to, my lord, various, my lord, other citation, my lord, court has held, my lord, here. Now, thereafter, my lord, the Honorable Meghalaya High Court also, my lord, in the subsequent judgment, my lord, in subsequent last two judgment, my lord, it's a, my lord, involving, my lord, a victim girl of 7 years, 17 years, my lord, approximately, below 18 years, my lord, had taken a pragmatic view, my lord. And, my lord, referring to earlier, those Madras High Court judgment as well as the Calcutta High Court judgment, my lord, which makes suggestion, my lord, for amendment, my lord, has also, my lord, accepted such, my lord, suggestion, my lord, and, my lord, the criminal petition has been quashed, my lord. So, my lord, considering those overall aspects of the matter, my lord, as I have submitted, my lord, the parties desire to live, wishes to live, my lord, heavily in the matrimonial health to continue, my lord. So at this stage, my lord, if, my lord, trial is put to the petitioner, my lord, then, my lord, that will be, my lord, giving, my lord, putting him in trouble, my lord. So justice, my lord, in such a case may not be actually made out, my lord. No doubt, my lord, allegation is there, FIR was registered, my lord, due to some misunderstanding as has been, my lord, deposed in their affidavit, my lord. So Lordship may take a call, my lord, and Lordship may, on any condition, my lord, Lordship may take pragmatic view, my lord, if situation should, my lord, petitioner should deserve, my lord. They are very young age, my lord.
My lord, here I have gone to the record, my lord. The death of incident of 11/10/2016, my lord. And admittedly, he was minor at that time, my lord. Our death of birth is 26/4/2001, my lord. And FIR was lodged on 13/10/2016, and it was registered under 366A. But during the investigation, we found sufficient material that is present in our matter, and parties submitted under section 363. Entire minor statement minus one is repeated where birth and sexual judgment and it was there interpreted in the minor. Of the minor other materials for medical report, document kindly say that I have checked my method. Her age is 16 to 17 years. And my assignment on April. Although the varies but after the opinion majority matter, it is not the ground for the passing of the eligibility is a minor at that time and offense was committed when it was minor. Therefore, it is not the case of passing. Our judgments are there regarding the matrimonial dispute. Matrimonial dispute can be passed, but here's the POCSO, or is there, which is the very serious and serious offense manner. Such type of heinous offense manner, murder, death, hypocrisy, cannot be passed. In the victim cannot pass. Even if there is settlement manner, that cannot be passed. My submission manner, it is not a case of passing manner, and marriage is not a ground for passing of the such type of heinous. That is my submission. Hashtag my medical. Here information is also there, madam. But the matter is already stated in the state. It is statement. And what if 5 days there it may be bracketed. So it might have is part of. Six. My and chemo.
My lord, just one thing, my lord, you kindly lordship to supplement, my lord.
Oh, you have submitted a lot.
No,
What do you want
No,
to submit?
just to, my lord, reply, my lord. Just one line, my lord. Whether the incident is out of compulsion or out of love. Lordship may kindly record this here.
Immediately out
That
of
will
love.
speak. And medical report, as I have heard, my lord, there is absence of such, my lord.
Such what?
Hymen is not there, as my lord, she said. Medical report does not say so, my lord. So whatever 164, my lord, if any, my lord, at all, I have not gone through 164 statement, my lord. If any contrary, my lord, that will be, my lord, maybe at that time he was not that much strong enough to say, my lord. And now they have already regret their mistake, my lord. That's what I'm submitting, lord.
But and chemo done it. We shall not learn it. Additional people bring on the. Your name is not here. Appearing on for whom?
Yeah.
Appearing on behalf of Mr. A. Ahmed.
J.
J. U. Ahmed.
J. U. Ahmed, my lord.
J. Ahmed. Respond number 2 and 3. Comma of informant and victim of offense. It's an application for a CRPC. April section 227. The implement FIR dated 13/10/2016 and the criminal proceeding arising out of said. Right, submitted Mr. Mori counsel for the petition that that an FIR has been lodged against. Where is the FIR? FIR is that
Page 13, my lord.
FIR has been lodged against the present petition by the informant of the respondent number 2 with an allegation that his minor daughter been kidnapped by the present petitioner from their lawful custody. Accordingly, case was registered in the section registered by DFU PS case number 220 of 2016 under section 366A IPC. However, during the investigation, the charge sheet has been filed against the present petitioner under section 363 IPC, read section 4 of the POCSO Act. Case is presently at the stage of charge hearing. However, as the stay order is operating, the case is still at the stage of framing of charge. Next, Mr. Murray, the learned counsel for the petitioner, further submitted that the FIR was lodged on 13/10/2016 for the incident occurred on 11/10/2016 at 11/10/2016, and admittedly at the time of lodging the FIR, the victim was 15 years 6 months, as her date of birth is 24/06/2001. However, there was no such incident of physical assault was taken place during at the relevant point of time. But it is a fact that both of the accused as well as the victim went eloped, the fact that the victim eloped with the accused out of love and affairs, and thereafter they also got married on 25/06/2019 and 2019, and at the relevant time of their marriage, the victim of the respondent number 3 was more than 18 years 2 months. One child is also born out of their wed on 12/10/2020, and at present the petitioner as well as the respondent number 3 are residing happily as a husband and wife. It further submitted that several high courts have already taken a view that the age of the victim in case of POCSO should be reduced to 16 years, as at present, as nowadays the most of the victim as well as the child above 16 years attains sufficient maturity to take a decision. Next, he further submitted that there are he also relied on several judgments of Honorable Apex Court as well as the Honorable High Court, where it has been considered that the High Court should liberally invoke the power under Section 480 CRPC while dealing with a case of washing, especially in case of matrimonial matters, where both the parties are residing happily out of their marriage. He further submitted in the present case, so the case is registered under Section 4 of the POCSO Act, but at the relevant time of incident, there was no such allegation except the allegation of kidnapping was brought against the present petitioner. Further submitted as both the respondent number 3 and the accused petitioner are residing happily as a husband and wife. The future prospects of the child born out of their wedlock, as well as the future of the victim and the accused should be considered, where only out of love and affairs they have eloped with each other and got married. Next part, that as the accused petitioner and the respondent number 3 already got married with each other and living happily as a husband and wife, there is no chance of there is no chance that the petitioner would say against the respondent would depose against the petitioner, even if the case is proceeded, and in that event, it will be a futile exercise of the court, and the futile exercise of the court, where the futile exercise of the court. Considering all these circumstances of this case and the view of the Honorable Apex Court as well as the view of the other high courts, the prayer for washing of the present petition may be considered at this stage. Next part. Mr. Mori further submitted both the victim and the informant, that is the respondent number 3 and 2 respectively, have filed their affidavit in the present case, wherein it is categorically stated by them that only out of some misunderstanding the case was lodged against the petitioner, but at present, after their marriage has been solemnized, both the victim of the respondent number 3 as well as the petitioner are residing happily as a husband and wife, and hence considering this aspect of the case, the prayer for washing may be considered by invoking the inherent power under section 482 CRPC. Next. The following judgments have been relied by the learned counsel in DD1. Next one, Mr. Sharma, the learned petitioner, submitted in this report that the admittedly the occurrence took place on submitted that the occurrence took place on 11/10/2016, and admittedly the victim date of birth of the victim is 26/04/2021, and thus she was a minor at the relevant time. From her statement as well as from the medical evidence, also it is seen that there was a physical contact between the parties, and during the medical examination, the hymen of the victim was also found absent, which otherwise suggests that there was a physical relationship between the parties at the time of filing the charge sheet or during the further submitted that this is a very heinous offense, wherein the power of under section 42 CRPC should be exercised sparingly unless the matrimonial dispute, it is not a case of matrimonial dispute, wherein allegation of sexual assault has been brought against a minor. Mr. Sharma accordingly raised or submitted that it may not be a fit case to squash the proceeding for quashing of the proceeding by invoking the power under section 480 CRPC. Next part, Mr. Deck, the learned counsel appearing for the informant and the victim, that is the respondent number 2 and 3 respectively, has submitted that presently both petitioner and the respondent number 3 are happily residing as a husband and wife with their minor child. Hence, considering this aspect of the case, both the respondent number 2 and 3 has no objection if the proceeding is quashed, the criminal proceeding is quashed against the present. Considering this submission made by learned counsel, case record. Get a
Value place, my lord.
No, I have not completed. I'll complete. I have recorded your submission.
One important point is that during the investigation, he was not cooperating and he was declared something.
Sharma তাতে power line. Mr. Sharma further submitted that during the inquiry also, the petitioner
Not
referred
declared by the
cooperated
bid in
in the
court, my lord.
investigation, and for which he was declared as an ex-convict. I have recorded your submission. You take it as by following satisfactory development. No, it can.
I'm a place, my lord. I'm sorry, my lord, for pertaining, my lord.
Pardon?
No, no, I'm sorry, my lord, for overloading, my lord, with so many citation, my lord.
No, I'll be.
Oblige, my lord.
One. Ito ang mga item ng ultima. I went home after
May I please, your lordship?
I was there.
Well, what happened? Your lordship, I think, remember, your lordship gave me a protection because there was no affair and a report was called for. Report has not come today. But one IA we have filed because meantime now I appeared to the police station and requested the IA, if anything, I am ready to give my statement. Police has said not now, we will call you again. Now my lord, case has been registered. Postmortem also done. Medical report is that it is a normal death. So my lord, what I pray that kindly call for the CD and report my
So what is
CD.
I for?
I also we apprise your lordship. This is the development. Now, earlier there was no case. Now case has been registered.
Yes, Sharma, you have received the report.
Hi, hi.
Item 24.
Only CD may be called for, my lord.
But here mentioned that one case has been registered at SPC.
Yes. Now case
Number is not here, my lord.
number we have given, na? We have given the number. Because we went to the police.
Dispute PS 186 of
Hi,
2020.
yes, exactly. Interim protection, court has granted protection, not to coercive action.
No, it is against one Aryan Kashyap is already here.
My lord, here. Aryan Kashyap.
Yes. The case has already been registered.
My lord.
Now case has been registered. Earlier there was no case, madam. So that's why I am praying that CD may be called for, madam, with medical report. Postmortem report, CD, madam.
Administrative Sharma Dilani, action on
132. Yes.
It is submitted next, right? Submitted by Mr. Sharma. That case has, as per the report, my case has already been registered against the present petition. However, there is no further mention under which this is in that context, Mr. Response, the learned counsel for the petitioner submitted that they have already filed one petition. Apprised the court that case has already been registered under section under the dispute PS case number 186 of 2025. Section 103.
No,
subsection
132.
103 subsection 1 238 and 3 subsection 5 of the 61 subsection 2 of PNS. However, the petitioner had already appeared before the police station and cooperated in the investigation. Next, considering the submission made by Rani Counsel for both sides, let the case diary for dispute PS case number 186 of 2025 be called for along with the medical of the PM.
Postmortem report.
PM report is,
And but earlier interim shall continue.
when it can be called.
My lord,
There'll be,
8th of April. 8th of April.
Give on eight.
because of
Where is
election,
the
all
list
police
numbers
officers
of
are
matters
busy.
on eight?
Then 23rd month, 23rd,
25,
23rd,
25, 3,
Is
23rd,
23rd of April,
March.
April.
April.
23rd of April, also interim.
I
will
just-
continue till next. Okay, your interim will be continued, we are listing it on 23rd.
Continue, madam.
Yeah, please, your lordship. Lordship, in this lordship, 8,79,000 a year amount was due to the respondent lordship. And up till now, lordship, we have paid 4,35,000 to the respondent, and only 4,44,000 has been still pending, lordship. So my proposition is that,
Outstanding was how much?
lordship,
I mean, outstanding was how much?
8,79,000.
8,79,000,
Yes, yes.
out of which how much you have paid?
4,35,000 has been paid.
4,35,000.
35,000. Now 4,44,000 is pending, lordship. And that apart, lordship, I have been regularly paying 15,000 as monthly maintenance to the respondent, lordship. I have filed 2 additional affidavits, lordship, wherein I have stated that his physical condition, lordship. So he is suffering from renal diseases and the
Elderly disease.
lordship,
Elderly disease.
renal disease, lordship, kidney
Oh,
stone,
renal.
renal disease. And recently, lordship, in page number 85, lordship would find he has made an accident when his right arm has been dislocated, and he's advised to carry out the surgery, lordship. And in page number 97, lordship will find that he has married out his younger daughter, who is born out of the marriage of the respondent, lordship. Recently, he has 2 great occasions, lordship. He has been suffering from
So marriage of?
marriage of younger daughter, who is born out of the marriage with this respondent, lordship. It is
Younger
second daughter.
daughter got already married.
Now, lordship, recently it was on fixed on 11th of March, lordship. So he is incurred some huge amount, lordship, in marrying out the girl also, and also he is suffering from his right arm has been dislocated, lordship. In page number 85, lordship would find the photographs and the medical document also. So his proposition is that, lordship, he is ready to pay in installment the outstanding amounts in installments, lordship. He is paying 15,000 per month. He is saying that if he could be afforded an opportunity to pay another 10,000 along with this 15,000, he would pay 25,000 per month, and thus he would uh, complete the entire year amount, lordship.
What he do?
Lordship, originally he was doing some business. Now, as of he is suffering from renal disease and also from accident, now he is workless, lordship. So he has his another son also, 1 daughter, 2 son also, and second wife is also there with him. So he has to maintain everybody, lordship. And his respondent also knows very well his physical condition as well as his incidents.
Okay, you have already paid and the remaining part is there, it's okay, I can understand. But the question is that 15,000 is okay for the maintenance you have paid. You're paying.
Yes.
Additional 10,000 you want to pay.
Yes, lordship.
How long it will take to complete the?
No, it will take
Yes,
some time, lordship.
4 lakh
I'm not denying that it
44,000
will take
remaining.
time, lordship.
See the question.
But the condition is that he is not in the position to pay the amount, as because he has lost his work, lordship, due to his disease. I'm already enclosing all the documents, medical documents. This is not a false statement, lordship. You will, lordship, would find me in page number
No,
48 or what?
we're not saying that. Yes, Mr. Chakraborty, do you
Not,
want to agree? with it?
Lordship, I come to page, Lordship judgment at page, our affidavit, Lord, page 20, annexure 1. But he's stating that the eldest daughter, during eldest daughter marriage, he didn't pay any single penny. The second child was staying with her, with him, Lord.
Yes,
That's why
Lord.
he married. During the eldest daughter marriage, he didn't pay a single penny, Lord. Lordship judgment at paragraph 8 here, Lordship stated that everything how essentially sound he is.
In which page?
Paragraph 8.
Paragraph 8 of
Of your Lordship judgment, that will page 26 of my affidavit, of my IA, of the IA, IA 83 of 2025. Since July, he hasn't paid any ADR amount. He pay another 2 lakhs. Paragraph 8. Page 26.
Yes.
Maybe. But then, right, how is it? Married mother, process, position as private process. This is actually sound. Hospital has rejected that revision petition. Upholding the judgment and order. Yeah, at least 2 lakhs. And thereafter, less than 2 No, but this affidavit has been filed as copy has not been sent to us. Not done through this.
No, Arislam Secretary. Arislam of Arislam. No, temp staff. His name is there in the Ukalatnamal accordingly. No, no. Anyway, যদি কপিটা লাগে মই দি দিম বাৰু
Yes, obviously, you go by the, yes, I can understand your physical condition or you're now suffering from some renal disease and all. It's okay. But 4 lakhs cannot be paid the installment of 10,000. It's just visualizing how it can. 10,000 per month for
That will
4
be
lakhs,
too much, that
4,000.
Definitely, Lordship. I also
Practical.
admit that it would take a long time. But his financial condition has to be looked over, Lordship, because he is suffering from renal disease. He is under medication.
Somehow you manage at least 2 lakhs, as Mr. Chakraborty is saying. If you can manage at least 2 lakhs at
At this
one
stage, Lordship,
instant.
At this place, why it is not possible? Because he has to undergo surgery for his right arm. And then he has already spent a huge amount in the marriage of the younger daughter. Lordship. So at this stage, it will be not possible. And some amount, maybe lesser amount, maybe Lordship may direct it 50,000 or something. Lordship. Then he will try to manage. And then thereafter, Lordship, I'm not denying that he will not pay.
In that case, do one thing. Passing an order of directioning this so and so may not be so easy. So you do one thing within that, we'll give a time at this 1 month, is okay for you.
Lordship, one
for
thing one
paying
may
another
Lordship do.
40,
I am
or may
also,
not say 1 lakh.
I also understand the condition of the respondent, Lordship. That is why one thing we may do, Lordship, 2 months time may be given and we will try to pay 1 lakh. And thereafter,
Or by that time, you're going to pay 15,000 per month.
no, Lordship, 15,000 I am been paying. That amount will be paid continuously. The rest amount, from the outstanding amount, Lordship, 1 lakh may be allowed to pay within 2 months, Lordship.
2 months.
Month is a long time.
Not long time, because
Pay 1 lakh before Bihu, Lord.
Lordship, he has to first he has to undergo his surgery. It would amount, it would cost is a heavy amount, Lordship.
1 month, then after Bihu. At best, after Bihu, 1 month. Try to accommodate. I'm not giving any direction, just I'm saying that some installment should pay. And then your prayer may or may somehow it may be considered. I cannot say at this stage,
Exactly.
because now 4 lakh spending penance is quite a
Yes,
big
Lordship.
amount, isn't it?
Okay, Lordship, I will try
Right. In that case,
prior Bihu or after Bihu. I will try to.
we are giving you a date after Bihu.
Yes, Lord.
Try to accommodate, give at least one installment of 50,000, say at least
Yes, please.
prior Bihu, and
Sure.
that within the period of the listing, so that you can pay another, say 50,000, say 1 lakh.
Lordship.
Otherwise, 1 lakh or 2 lakhs may be difficult on your part also. But as Mr. Chakraborty had read out, you have a good earning, in fact.
No, Lordship, that in the order, if you see the judgment of the family court order, their claim has not been substantiated by any other documents or by any evidences, Lordship. This was rejected. Their claim was rejected in the family court order, Lordship. That is why court has granted 15,000 only. It was their submission, Lordship, but it was not allowed. It was rejected, Lordship.
Heard Mr. KK. It's subject that there was an outstanding due of rupees 8 lakhs, 79,000, and out of which the petition has already paid is 4 lakhs 35,000, and another amount of 4 lakhs 44,000 still pending or due to the However, as presently his financial condition is not so good, as he has suffering from some renal diseases, and apart from that, he also met with an accident in which there was a dislocation of his right arm, which also needs surgery. Apart from further, he is had to spend a huge amount of money in for marriage of his younger daughter, and hence it is submitted by Mr. Handy this time may be given for him to pay an amount towards the due towards the pending area. Mr. Chakraborty stated that petitioner is still have a good earning sources, and with the competitors, and on the other hand, the any sources for his income or for her maintenance. Considering the case and this the will matter be listed. It about be see matter 28 of April, enabling the petitioner to pay some installments towards the area maintenance. Let the matter be accordingly listed. We are listing it on 28th of April. If we use some accommodation,
try
that, it can be at least 1 lakh, 1.5, whatever you can. Okay, then we can see it. And by that time, the 15,000 which you are paying,
that will be
for
continued.
paying those.
Lordship.
Be heard. Kalani.
26. 26, I have received the report.
You are three petitions.
Three petitions.
Till now, though, there is no case.
There is no case.
If suppose in future any cases is,
Yes.
then you are at liberty.
I am giving it liberty.
Heard, Mr.
B. Fukon.
26. Mr. B. on internet copy. Supreme Court. Internet additional PP. Report received from officer in charge for police station, when it is reported that till date, no case has been registered against three petitioners mentioned. In view of this, present report received from a police station be kept. Petitioners will be at liberty to approach the appropriate court of law in the event any case is registered under any station.
Quickly obliged.
Wait, please, your lordship. So this,
11, we have received this scan copy. Na?
yes,
Yeah.
lordship. Your lordship have challenged this petitioner, challenged the order, lordship, to find on page 15, lordship. Page 15 is the interim order, lordship. May I read, lordship?
Yes.
Accused Bidu Sarkar is present along with his learned advocate. I have heard such and such learned P.P. Baksha as well as the learned advocate for the accused person on the point of framing of charges. I have gone through the case record and case diary and the relevant document submitted by the IO. It appeared that there is a prima facie sufficient material to presume that the accused Bidu Sarkar has committed the offence under section 448, 376, 1. 294, 506 IPC, hence charge frame under section 448, 376, 1, 294 and 506 of the IPC against the accused Vidhi Sarkar. And the content of the charge read over and explained to the accused person to which the individual pleaded not guilty and claimed to be tried. Issued summons, lordship. Where I have challenged this, there is no ingredients of 376, 1, lordship. Where I am challenged, lordship, kindly come to the FIR. Here victim is the informant, lordship, because Bishaka Sarkar, 27 years old.
Page number.
Page number 18, lordship. Translated portion, lordship. It is respectfully submitted that on last 14/1/24 night at about 8 p.m., accused Vidhu Sarkar of our village entered into my room in absence of my husband in drunken condition and assaulted and abused me with filthy language. Later, I raised hue and cry. Then my brother-in-law, Ramcharan Sarkar, came to resist, then assaulted my brother-in-law and accused grievous injury on her head. It is therefore prayed that your honor kindly take necessary action as per law, and it is my humble prayer. Such and such lordship case was registered as section 448 to 94, 323, 325, and 506. From the plain reading of the FIR, lordship, it said there is no whisper regarding rape, lordship. After that, lordship, the statement of this victim along with all the
Prosecution witness lordship, 161 statement lordship, although it's not evidential value lordship, may I read what she has stated before the IO lordship in 161 statement lordship. Page 22 lordship, 23 is the lordship, vernacular lordship. Page 23 lordship, got it. মোৰ নাম আৰু ঠিকনা ওপৰৰ মতে ইয়াৰ লৰ্ডশ্বিপ কমপ্লেইনেণ্ট ষ্টেটমেণ্ট লৰ্ডশ্বিপ মোৰ নাম আৰু ঠিকনা ওপৰত লিখা মতে সত্য মই এগৰাকী গৃহিণী মই যোৱা 14/1/2024 তাৰিখে প্ৰায় 8টামান বজাত শ্ৰী বিদু চৰকাৰ নামৰ ল'ৰাজনে আমাৰ ঘৰত আহে সি মোৰ ৰুমত নোকোৱাকৈ নেমেলাইকে সোমাই আৰু আহে তেতিয়া মই ভয়তে চিঞৰ দিওঁ পাছত মোৰ ওচৰৰ ৰুমত থকা স্বামীৰ ভাই ৰামচৰণ চৰকাৰ আহে বিদু চৰকাৰে মদ খাই আহিছিল সি কথা বাতৰ নোকোৱাকে তৰ্ক বিতৰ্ক কৰিব ধৰে নানান ধৰণৰ বেয়া কথা গালি গালাজ মোক আৰু ৰামচৰণ চৰকাৰক পাৰে পাছত সি মোৰ গাত হাত দিয়ে আৰু যেতিয়া ৰামচৰণ চৰকাৰে বাধা দিয়ে তাক মাৰধৰ কৰে যাৰ ফলে ৰামচৰণৰ মূৰত আঘাত পায় ৰামচৰণৰ পৰি যোৱাৰ পাছত সি মোক আকৌ মাৰে তেতিয়া বেছি হাল্লা হোৱাত ওচৰৰ শ্যামল মণ্ডল আৰু তপন দাস আহি পায় তেতিয়া সি আমাৰ ঘৰৰ পৰা পলাই যায় পাছত আমি থানাত আহোঁ আমাৰ মেডিকেল কৰা হয় লৰ্ডশ্বিপ নাও here also lordship no allegation of rape is there lordship now after that lordship other statement of the lordship prosecution witness has been recorded under 161 lordship I'm not going on that lordship now charge sheet lordship that is on page 32 lordship on the basis of the statement and after completion of the investigation lordship charge sheet has submitted that is on page 32 lordship charge sheet has submitted under section 448 294 323 325 506 lordship had it been a case of lordship rape lordship then the statement of the victim has to be recorded under 164A of the CRPC lordship within 24 hours what is the medical report lordship will find on page 38 lordship lordship got in the Vishaka Sarkar's injury report lordship kindly see the description of the injury physical assault I lacerated on the left elbow red in color age of injury fresh no injury on private parts lordship thereafter lordship this petitioner appear lordship someone has been issued lordship this petitioner appeared before the court and he was granted bail lordship now statement of the victim lordship the informant lordship has been recorded lordship before the court lordship her evidence lordship that is on page 43 lordship here she first time brought an allegation of rape lordship may I read lordship Vishaka Sarkar. I am the informant of this case. I know the accused person. The incident took place 14/1/24 at about 8 p.m. At the time of the incident, I was at home lying on the bed along with my two sons. That two sons has not been examined, lordship. My brother-in-law was at home, but my husband was not at home. Suddenly, the accused person broke into the house and caught hold of me and raped me. I could not shout because he shut my mouth with his hand. Thereafter, I somehow managed to shout for help. My brother-in-law came in to help me, but accused person caught hold of him and hit him and bashed his head on the wall. When I tried to help my brother-in-law, the accused person hit me. He also had a knife in his hand. Thereafter, he ran away. After some time, my neighbor took me and my brother-in-law to the hospital, and my brother-in-law got 11 stitches on his head. Thereafter, I lost the Azhar on the same day, exhibit such and such. No knife was recovered, Lordship. It is not a fact, cross-part, Lordship. It is not a fact that Vidhu Sarkar and my brother are good friend. It is not a fact that I did not state it before police that the accused person broke into the house and caught hold me and raped me. I could not shout because he shut my mouth with his hand. It is not a fact that the accused person did not have knife in his hand. It is not a fact that other person, Lordship, not so relevant in this case, Lordship. Now, Lordship, kindly come to the other witness, Lordship.
But
Independent
just-
witness,
just-
Lordship.
just- This evidence was, the petitioner, I mean, the informant victim was recorded by JMFC.
Yes, Lordship.
And who framed the charge?
Session judge, Lordship.
Session judge on which date?
That is Lordship on page 15, Lordship. Session judge Baksha, Lordship.
Case has been committed there.
Yes, committed, but now, Lordship, here important is the Lordship, the medical report, the evidence of the doctor, Lordship, and 53, that is on page 53, PW6. Lordship got it. May I read, Lordship, on 14 what? May I read only the injury portion, Lordship? There was two numbers of cut injuries on the Ramcharan circle on the scalp of such and such, as active bleeding was present. There were lacerated on the elbow of Vishaka circle, which was red in color. Opinion, the injury was found in simple in nature. The injury was done with a blunt weapon. The age of the injury is fresh.
How many evidence were recorded by the JMFC?
7 witnesses has been examined by the KMC.
Already examined, and
Yes.
thereafter it was set.
Yes, Lordship. Now, Lordship, IO's statement, Lordship, will find on page 54, Lordship. IO said, Lordship, the informant did not stated before him, Lordship, regarding rape, Lordship. That is on page 54, Lordship. May I read, Lordship? IOPW 7, Kuldeep Gauhati. Had it been a case of rape, Lordship, that investigation ought to be done by a lady officer, Lordship. On 17/1/24, I was posted at Kumrikata OP in charge on the day of an Azhar was lost by the Srimati Vishaka Sarkar. It was registered by OC Tamulpur. Since the place of occurrence is under Kumrikata OP, I was endorsed for investigation. The case was registered as Tamulpur PS case number such and such under section 448, 294, 325 and 506 IPC. I record the statement of complainant Vishaka under section 161 CRPC. Thereafter, I visited the place of occurrence on 18/1/2024 and draw a sketch map. I recorded 161 statement of the Sam Mondal and Tapan Das. I took for the accused person, but not find him. On 22/1/24, the accused person appeared before me and in the OP. And after interrogation, he was released on bail. It was a bailable offense. Thereafter, I collected the medical report and submitted the charge sheet against the accused person under 448, 294, 323 IPC exhibit such as exhibit 3 P3 and PW7 is the sketch map. Other part is not relevant, Lordship. Now come to the cross portion. The case was endorsed to me on 17/1/2024. After 3 days of the incident, I recorded the statement of the witness at the place of occurrence. The informant did not state before me the accused person raped her. Specific, Lordship, the informant did not stated before me that the accused person raped her and she could not shout for help as the accused person caught hold of her mouth. The informant did not stated before me that the accused person had a knife in his hand. The informant did not stated before me that the accused person based her brother-in-law Ramcharan Sarkar against the wall, but she did mention that The accused person hit him on the head. The informant did not stated before me that her brother-in-law Ramcharan Sarkar got 11 injuries, 11 stitches on his head. Samuel Mondal did not stated before me that he saw the accused person scratching the neck of the informant, but did not mention that he saw the accused person hitting her. Samuel Mondal did not stated before me that he poured water on the head of the Ramcharan Sarkar. Samuel Mondal did not stated before me that specifically that he took the informant to the to which police station. Tapan Das did not stated before me that he went to the informant house specifically from his house after hearing the hue and cry, but he did not did mention that he went to the informant house after hearing the hue and cry. Ramcharan Shankar did not mention before me that the informant was lying on her bed with her son. At the time of the incident, Ramcharan Shankar did not stated before me that the accused person was raping the informant. Specific, Ramcharan Shankar did not stated before me that he was burst against the wall by the accused person, but did mention that the accused person hit him. Ramcharan Sarkar did not state before me that he become unconscious. Ramcharan Sarkar did not stated before me that the neighbor pour water on his head. Ramcharan Sarkar did not stated before me that the accused person caught hold of the informant by her hair and pull her on the ground. Ramcharan Sarkar did not stated before me that the 11 stitches on his head. Madhusudan Sarkar did not stated
It's okay.
before me that part, Lordship. Now, Lordship, only independent Lordship there, PW.
This is the order on page 56 by which the case was committed.
Yes, Lordship. There is no ingredients of 376, Lordship. Only statement of the victim, Lordship. Not even her statement was, Lordship, she was medically examined, Lordship, she was reported to the doctor regarding rape. That was not there, Lordship. I'm only against the charges, Lordship, 376, whether it is tenable in the, after going through this evidence, Lordship. There must be prima facie Lordship ingredient to constitute offense, Lordship, 375, Lordship, and subsequently punishment under 376. That is not there, Lordship. So in this case, Lordship, on that ground, Lordship, I'm praying for quashing of this impugn order, Lordship, specifically the 376 charges, Lordship. In this regard, Lordship, I'm relying in one judgment, Lordship, may I place only para 14, Lordship. Para 14, Lordship. May I read, Lordship? When an accused seeking quashing of either the FIR or criminal proceeding on the ground of such proceedings are manifestly, fabulously, and vexatious and malicious, the court is duty bound to examine the matter with great care. It will not be just enough for the court to look into the abatement made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredient to constitute the alleged offense are disclosed or not. In frivolous and vexatious proceeding, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the abatement, and if needed, be with due care and circumspection and try to read the between the line. The court, while exercising its jurisdiction under 82 and of this code and Article 226 of the need not to restrict itself only to the stage of the case, but it's empowered to take into account overall circumstances leading to the instigation and registration of the case as well as the material collected in the course of the investigation. Here, Lordship, material collected during the course of the investigation does not supported the section 376, Lordship. So since there is no ingredients of Lordship 375, Lordship, may I pray, Lordship, this impugn order kindly be quashed, Lord.
Yes, yes, my lord, already pointed out here. I have also gone for the record. My lord, incident occurred on 14/1/24. My lord, FIR, my lord, no allegation of rape. No allegation of rape in any of the 161 my lord, victim and other witnesses. It also not filed under section 3. And my lord, there is otherwise there is no supporting my lord material to my lord, just the ingredients of 76 is there. But there is no. So for the first time, my lord, deposition of PW was taken in the court on 5/6/24. After the my lord incident on 14/1/24. So on 5/6/24, that my lord during deposition, PW1 my lord for the first time stated that the accused person has committed rape. And my lord during deposition, my lord PW2 who has also not earlier.
But the case was also not committed immediately after recording of the statement of the PW1.
Yes.
All the witnesses, maximum PW7 up to 7, we
Yes,
have recorded, and
They are
thereafter.
after, not only after PW1 and 2, after recording, my lord, up to PW7, my lord, matter was pointed that paper. Yeah. But otherwise, to support the my lord, ingredients of it, there must be some material. But here in this case, only my lord, otherwise, my lord, from the date of the incident, my lord, nowhere there is ingredient. Time of issue, my lord, what is there is that. Now, my lord, question is, my lord, whether, my lord, while there is no material to support, so on the basis of the statement of the victim on later stage, while during when the my lord session court can when part of section 370 without taking regarding other sections, my lord, regarding all
Yes.
other sections, there are material.
There are,
Regarding
there.
325,
There are.
323, 294, there are to expect.
But the charge sheet was initially filed on
Search
248.
sheet was filed under section
294 and
325.
No, 376.
but as per IO, he filed charge sheet on only on
filed on
448, 294 and 322.
31, 120,
31?
120.
No, no, no.
No, no, under section 448, 294 and 323, Lordship. That is on
Yeah.
page 54, Lordship.
That is my lord search. Search sheet submitted under section 294, 323, 325 and 306. That is search sheet submitted.
Charge sheet was submitted. The charge was framed on 448, 294, 322.
294, 323, 325 and 506.
No,
448.
charge was framed on which? Initially.
Initially, charge was framed on the same section, Lordship, to the 448, that is on page.
448, 294.
Lordship, allow me. Lordship, order on page 56, Lordship will find. Page 56.
Yes. 448, 296.
That was the order. 448, 294, 506.
Yes.
Charge was initially framed.
Yes, Lordship.
Oh, no, no. Charge sheet was.
Charge sheet was filed and charge was framed according to same section, Lordship. Subsequently, Lordship, 376.
Whether there were medical evidence also on that, is there any sections? No, what I'm saying, the charge sheet has already been, charge sheet was filed definitely under
Charge sheet was
448.
filed and thereafter, my lord, that is, my lord, before, my lord, evidence, before charge, my lord, those evidence Every time of
After 313 statement, 376 is the
initial search framing order.
initial order recorded.
I mean, under which section initially charged was, that's what I'm
I will point out.
record.
Lordship, that is on page 42, Lordship.
Yes. 448, 323 and 94.
Yes.
Yes. Okay.
Part about done in 58, 88, for 482 CRPC for setting aside caution impute charges framed under section 448, 376, 1, 294, 506 IPC on 17, 12, 24 by learned sessions case number 142 of 24. Learned session del Paksa, learned session del Paksa in sessions case number 142 of 24. And also date for washing of the impute order dated 26/09/2024, passed in PRC case number 58 of 2024. Learned JMFC Paksa, also in connection with Amutpur case number 13 of that an FIR was lodged against the present accused petitioner with an allegation that the night incident, that is on 14/1/2024, about 8 p.m. the present petitioner entered into the house of from in a drunken condition and assaulted the victim and also abused her with victim, hearing her human cry, her brother-in-law Amsharat came to resist him when the accused petitioner also assaulted her brother-in-law and caused serious injury on this person. He submitted that there is no mention about committing rape by the accused petitioner on the night of incident on which the FIR was lodged by the and the learned trial court below, that is it, the learned JMFC Baksa also framed charge against the present accused petition under section 448/323 by 294 IPC, considering the materials on record, statement of the witnesses. The case accordingly proceeded, and the 7 numbers of witnesses have already been examined by the learned JMFC, including the informant of the victim, medical officer, IO, and the other witnesses. He further submitted that those witnesses never uttered anything about the rape committed on the victim, and the only allegation against him is that he entered into the house of the informant in the night of occurrence, assaulted her and also assaulted her brother. The medical report of the victim, both the victims also speaks in regards to some bodily injury on a, the victim of the informant as well as her family. That apart, there is nothing been mentioned in the statement made by the witnesses as well as the IO, any medical officer regarding commission of rape by the accused. By the accused. A post of further, the victim also did not drop any allegation of rape while her statement recorded section 61 CRPC. She simply brought the allegation of uttering, abusing her and assaulting her along with her brother. Surprisingly, first time the informant victim as a PW1 brought the allegation of rape against a present petition, and to that extent she was also examined, cross-examined by the defense. Except her simple verbal statement in the FIR, there is no materials to frame charge against the present petitioner under section 376(1) IPC. And in the same time, from the medical evidence as well as from the evidence of the evidence of the IO, she never uttered anything about the commission of rape on her by the accused petition. According to Mr. Chaudhary, the learned counsel for the that learned trial court below that as the without the order dated 26 order is at page
Page,
trial court order.
that is on page lordship, 15 lordship.
No, 56, no? It is dated 26/09/2024, committing the case before the learning session judge with an observation that offense under section 376 IPC has been made out in the present case. Further, he submitted that considering only the order passed by the learned trial court below, the learned session judge Baksa had passed the order, implement order dated 17/12/2024, whereby without going any materials, without perusing any materials on record, without even applying it to cell mine, had framed the charge under section 448, 3761, 294, 5056 IPC. Hence, the said implement order is liable to be set aside and quashed. Next, Mr. Board, submitted in that the fact that the FIR is lodged against the present petitioner only with the allegation of criminal intimidation and assault on the victim as well as her brother-in-law, and it is also a fact that there is no materials to support the case of the prosecution to establish a case against the petitioner under section 376 IPC. The medical report, the evidence of the IO as well as other independent witnesses also do not support case of the prosecution under section 376 1. He further submitted that as per the medical evidence also, the petitioner, the victim was not examined for any rape as a rape victim, but only as per the allegation of assault. She and her brother-in-law have been examined according where some minor injuries were found in their person. Mr. Godford according fairly submitted that there is no material to support the case of the case under section 376 IPC against present petition. Getting the submission made by London Council proposals have also failed. The case record and also the evidence of the PWs recorded by the learned trial court below before committing the case to the Court of Learned Session Judge by its order dated 2609. It is the admitted position that in the FIR there is no ingredients of rape or there is no allegation brought against the petitioner. Further, it is also seen that in her statement made in the section 161 CRPC also, the victim never raised any allegation of rape on her, neither allegation of rape on her. Further, the statement the other witnesses also did not brought any allegation of rape against him, and allegation of rape as per as pointed out by Mr. Choudhury, it is seen that the medical evidence is also silent in regards to any sign of rape, and the victim as well as her brother-in-law were only examined for the assault or the injury they have sustained on their person. From the evidence of the eye also, it is very evident. It is evident that the victim never made any allegation, brought any allegation of rape against her, and it is for the first time in her evidence as PW1 she made a statement that the accused also committed rape on her. So it is the admitted position there is no materials or evidence against the present petition to frame charge against him under section 376(1) IPC, nor there is any material to commit the case record before the learned session judge by the trial court with an observation that there is ingredients of 376 IPC in the case. Since 2609/2024, by which the case was committed before the learned session judge, as well as the order of framing charge by learned session judge Paksa dated 17/12/2024 needs interference of the scope and according to the orders of students set aside. The learned session judge is hereby directed to pass necessary order to that liquor, and if it is not a case of committed in nature, the matter may be remanded back to the learned trial court below for further proceedings. With the observation, the present
Highly obliged.
Now the case will proceed for the state of it will come remand back to the CGM.
because on oath 7 witnesses have already been examined.
Yes.
Cannot.
Yes. Because the matter was remanded back to the committed to the court at the stage of recording my P1.
Yes. that from that stage only it will be
Yes,
this session just pass according
I live.
this. Yes, we have received here the scan copy.
Yes.
Yes,
May I, Lordship, please? My Lordship, this criminal petition, it was admitted by the small court, my Lord. And on 18/6/2025, this small court has 18/6. 18/6, the small court has passed an interim order. May I request, my Lord, to kindly see from paragraph 10,
on which 18/6.
18/6 to 2025.
So this is the order. Okay.
Yes. May Lord, can you kindly have a look at from the page, paragraph 10.
Para 10.
Para 10.
Yes.
So by that, on referring that judgment, my Lord, of
Yes.
2022, this Honorable Court was pleased enough to stay the further proceeding of the matter in issue, matter challenge before the Honorable Court. Now, herein, my Lord, at the outset, is no longer a res intriga, my Lord, Lordship is aware. The summoning of an accused is a very serious matter. So thereafter, unless there is a prima facie satisfaction of the learned court below, the summoning of an accused, that is not to be a routine matter. My learned brother in the earlier this matter referred to a judgment, my Lord, which my Lord has gone through this paragraph 14. But I would like to refer to this paragraph 13. This is a recent judgment, my Lord. We have a copy.
The earlier judgment too.
Yes. The Sujoy Ghosh, my Lord, is a 2 days back,
Okay,
the Honorable Supreme Court has passed on 20th of March. It was a universal set. Universal 26 time. It will principle. Summoning. Lordship, can you have a look at paragraph 13? Why I am citing this, my Lord? Yes, upon this principle, we have to analyze the facts of the incident matter, my Lord. Paragraph 13, my Lord. The principles governing summoning of an accused in a criminal case, as well as parameters for quashing criminal proceeding, are well settled. Summoning of an accused in a criminal case is a serious matter, and criminal law cannot be set in motion as a matter of course. It is not the complainant has to bring only 2 witnesses to support his allegation in the complaint to have the criminal law set in motion. The order of the magistrate summoning the accused must reflect a reflection of mind for the facts of the case and law applicable thereto. The magistrate must carefully scrutinize the evidence brought on record and determine whether an offense is prima facie made out. The magistrate may even himself put question to the complainant and his witness to elicit answers to find out the truthfulness of the allegations or otherwise, and then examine if an offense is prima facie committed by all or any of the accused. Now, basing upon this principle, my Lord, now what happened in the instant matter? The respondent number 2 hearing, he has filed a complaint before the learned magistrate, learned Chief Judicial Magistrate Dibrugarh, saying that these are the allegations. And I have filed an FIR before the Polish authorities dated 10/2/2022. The date is very important, madam. 10/2/2022, I filed a complaint before the police authorities, but police authorities has not taken any actions. So I am before this court. Now, in the court, they prayed for taking a cognizance and also praying for a call for a report from the police under section 210 of the series. May I request this honorable court to see the complaint first? Because you will find as page 23. Now, you will can file first the first page of the complaint, 23. Now, before referring to the, Lordship is aware that in a criminal case or any FIR or any complaint, there must be some dates to be mentioned. And also, there is a date of occurrence, place of occurrence, and the person who has committed such an offense. So there are three components in the criminal case which has to be set foot in the FIR or in the complaint. Now, Lordship will find here that they have stated that the date of occurrence is 11/9/2022, and also said on several occasions without mentioning any date. Now, therefore, the cause of action of the entire criminal matter that's alleged to have been occurred, that is referring to the date of 11/9. I will come to that 11/9. Kindly have a look at paragraph 4, my lord. Page 20. Why 11/9/2022? That on 11/9/22, CA Bijoy Shah, under pressure from accused number 1 to 3, lodged a fabricated complaint against the complainant. CA Sanjay Jain, chartered accountant, who is the complainant, and stated continuously asking to provide the same confidential document of C such and such. This is a organization, my lord. The complaint, they compelled him to visit the office to dictate him change such and such. So what they allege, one Bijoy Shah CA, he has filed a complaint at the behest of the accused. That is the accused number 1 to 3. That is the allegation, that is the referring that 11/9. Now, what you will find, paragraph 5 is the allegation against us. Now, the basic allegation, I'm not, this is a long para. So instead of reading the entire para, I mean, the nutshell what the allegation is, that after filing of the FIR by the Binoy Shah, chartered accountant, that FIR has been circulated in the social media group, in the WhatsApp group. And he alleged that some of the accused are the administrator or that, and they circulated this FIR in the social. And thereby, the image of the complainant has been tarnished and lowered down. That's the basic allegation in paragraph 5. Now you will find in the last part of the paragraph 5, such malicious circulation is adversely affected upon his reputation, position, status, honor, and respect, which is possessed in the society. Basically, what the allegation is, my lord, that the defamation. He has defamed in the eye of the estimation of the society. That's the allegation. Now, Lordship kindly comes to paragraph 7. That in view of above, on 10/10/2022, the complainant lodged a complaint to the police authority Dibrugarh, but till today, neither the statement of the complainant has been properly recorded, nor any case has been registered against them. This is the false statement. Why I'm saying so? Because their own affidavit before this honorable court, which is by an order of this court treated to be an objection, there says that no, not 10/10. They filed the first FIR before the police on 12/9, not 10/10. 10/10 they have filed before the SP Dibrugarh. The first complaint, that is the first FIR, because Lordship is aware that the first FIR is important, and all other FIRs or complaints that is the statement under section 162 is barred. So first complaint to be treated to be an FIR. The first complaint, my lord, that is on 12/9/2022. I will come to that. I will refer to that. Now, my lord, what's the prayer they have made? Page 27. It is therefore prayed that your honor may be pleased to take cognizance of the offence committed by the accused person under section such and such, and further be pleased to grant compensation. Next, also be pleased to call for a detailed report from the officer in charge Dibrugarh police station regarding the action taken on the complaint. So therefore, they have said that since we have filed a complaint before the police, so court may be directed to take a report. Now, Lordship will also be having look at the affidavit. Now, affidavit is saying affidavit, but is not an affidavit, my lord. Why I am saying so? Because the affidavit, only the contents he says, 1 to 6 of the complaint petition are true to my knowledge. Omitted 7 to 9. That's the filing of the complaint before the police, etc. No reference. And also there was no oath and affirmation in the affidavit. So in the eye of law, this cannot be said to be an affidavit. Because affidavit is required, my lord, since this application has been forwarded by the learned court under subsection 3 of 156 of CRPC. So as per the judgment of the Supreme Court in Priyanka Srivastava and later on by Justice Gauhati, that affidavit is mandatory requirement of saying by the before the court referring the matter under section 156(3). But my humble submission, respectful submission before the court is that this format of this affidavit cannot be said to be an affidavit in the IO. Now, on the basis of this, my lord, the learned court, the learned CGM, instead of call for a report, now, Lordship is fine that there was no annexures. Because the complainant, before asking the court to exercise power under subsection 3 of 156(3), must annex that whether he has approached to the police or not. But here it is absolutely clear, and it is admitted position in the record, my lord, that they have not annexed either 12/9/2022 complaint or 10/10/2022 complaint. Neither. So therefore, there was no annexures. So whether the before exercising subsection 3, the learned trial court must satisfy that the complainant has complied with section 154, that he has approached the police, then on being refused, he has approached the superintendent of police, and superintendent of police, after being no action has been taken, then the court. And this complaint has to be recorded, the statement that he has approached, and that complaint, that FIR, copy of the FIR has to be annexed. And the application has to be supported by an appeal. So therefore, Lordship will find they have concealed the information lost to the officer in charge on 12/9/2022, number 1. Number 2, either the 12/9/2022 complaint or 10/10/2022 complaint, they were not annexed with the complaint petition. So therefore, the subsequent order that is dated 21/1/2023, page 29, my lord, that is absolutely untenable, and that order is required to be interfered, my lord. So on the basis of this order, this complaint petition routed to the police, and thereafter the charge sheet was filed. The Lordship will find in this page 29, case record is received for disposal, learned counsel verbally prayed. It was not prayed in the complaint petition. It was not a petition under subsection 3 of 156(3). Verbally prayed to treat the instant complaint as an FIR and direct the IO to investigate into the matter. And thereafter, the learned court says, on perusal of the case record is revealed that the allegation revealed in the instant case under section such and such. Therefore, under the facts and even referred, my lord, is what the application of mind of the trial court. Well, referring to the section, also referred 199 and 200. It is not a penal section. And police also registered, since the court has referred, police also registered. No, 119 and 200. This is not a penal section. Police cannot investigate. Now, therefore, under the facts and circumstances, this court is the opinion that the case should be investigated to the police to honor the actual facts. Considering the entire aspect, the concerned OC is directed to investigating the case by registering case by treating the instant complaint petition the FIR and to investigate the matter and to submit it such and such. Now, there is a very interesting facts to be brought to this notice of this honorable court by law. Now, what you will find here, there are 4 complaints. Number 1, first is 12/9/2022. The Lordship kindly have a look at that complaint in their affidavit, my lord. To the eye. Yes. That is their IA, my lord, which is treated to be a written objection. 1191. Which is part of this criminal petition. We are thankful to this respondent number 2 to bring before this honorable court all those, because all those are not filed before the court, my lord. Lordship will find at page number 21 of the interrogatory application. My lord God. This is addressed to officer in charge, Dibrugarh Police Sadar, Dibrugarh, Assam. This is the first complaint they have lodged. Now, the contents of this affair is very important. Why I am saying so, my lord? Because there is no dispute by them that the incident, their allegations, their grievances arising out of the circulation of that WhatsApp. And they have said so in their first complaint. I would like to inform you that the following person with a view to malign the following person of the petitioner before this court. Malign me and associate in a malicious prosecution and also to cheat me, posted and circulated in a alleged complaint dated 11/9/2022 in the social media WhatsApp group that see Vijay Shah such and such lodged a complaint against me, and thereby they have purposely, deliberately, and with oblique motive posted such fact complaint deliberately in the social media WhatsApp group such and such, and caused it viral amongst the public and defamed and insulted me before the estimation of others by committing fraud and also by adopting dubious method. I am a chartered accountant by profession and also chairman of PBC of Delhi Public School, and such malicious calculation has adversely affected my reputation in the society at large, affecting my profession among the parents of children studying in the school. Now he has used some word fraud, cheating, but in context, my lord, it is only saying that he was defamed. By using some word of Indian Penal Code, that fraud, cheating, breach of trust, that does not mean that all those offenses were attractive. So the basic contents of the allegation is that he has been defamed in the eye of law due to circulation. Now, this is the basic allegation he has made. Now, my respectful submission, my lord, that this is the first complaint he has lodged. So, this to be treated as a complaint. Now, Lordship is aware that after Lolita Kumari case, any complaint, if alleged and cognizable offense, that has to be registered. Now, if it is a cognizable offense committed, if there is an allegation, that has to be registered. Now, whether it's a cognizable offense has been committed or not, if not registered, then the court will see that the jurisdictional magistrate will see that whether the allegation made by the complainant is alleging any cognizable offense. If alleging cognizable offense, and if is complied under section 154 all the ingredients, then he has to be referred the same for registration of the FIR. This is the settled position of law. Now, here twofold submission of that. Now, if it is treated to be a first FIR, then the lordship will find that the allegation is only centering around that the commission of the defamation. Now, the allegation of defamation by an FIR that cannot be registered, my lord. The defamation, any allegation that has to be treated by a private complaint. After Subramaniam case, it has been settled by the Supreme Court that if there is an allegation of defamation, it cannot be treated to be an FIR. It has to be routed through a private complaint. So this is my first submission. The second submission, lordship kindly have considered that thereafter the subsequent complaint cannot be treated to be an FIR. Now they have filed after this, lordship will find at page 22 the second complaint, which is referred in the complaint petition. That is, in page 22, lordship will find in their affidavit. Which is referred in para 7 of the complaint petition.
Page 22.
Page 22. Though it is not annexed with the complaint petition, but they have filed it. It is referred in para 7 of the complaint dated 21/1/2023. I have already referred it. Now here there was no reference of complaint dated 12/9/2022. Now what 154 says, my lord? The 154 says you first approach to the officer in charge. If officer in charge did not respond, then you have to come to superintendent police. And you have to refer your complaint of the officer in charge and also complaining before the superintendent that, see, I have lodged a complaint of your OC, but he did not respond, so please direct him to register. But they have independently, they have filed a complaint before the SP without referring of 12/9/2022, which also a erroneous approach of the complainant, my lord, and therefore the intervention of this honorable court is called. Now, lordship, kindly have a look at this, page 22. To the Superintendent of Police, Dibrugarh, subject complaint. So it is an independent to 11/9. Saying same thing. I have not read out. Saying same thing, only they have added on third paragraph, lordship will kindly last two lines. They have added to earlier. Third paragraph, 2 lines. Moreover, this person have been giving live threats to me using obscene language and abusive words, which is very concerning to my family, and request to take note and cognizance of the same. Now, it was not stated in 12/9, first FIR. So it is an improvement of this complaint. Now, this is the second FIR. Now, lordship will find that they will not stop hearing. The third complaint is dated 21/1/2023. That is the complaint before the court that I have already referred. 21/1/2023 before the Learned CGM Dibrugarh. That is the third complaint. Now, there was a fourth complaint. That's the interesting, my lord. That fourth complaint we could not find out in the record. That reference in the charge sheet.
Yes, see.
From the charge sheet, madam. In the charge sheet, they say that this respondent number 2 has filed an FIR complaint on 18/2/2023. Lordship, kindly have a look at page 30 of my criminal petition.
Page 20.
Page 13 of the criminal petition. Lordship will find there is a reference of an FIR dated 18/2/2023.
Yes.
Yes, एकदम first line में. District Dibrugarh, PS Dibrugarh, year 2023, FIR number 93, dated 18/2/2023. Now, Lordship will find this reference has been in the charge sheet also. Page 30, my lord. Page 30.
30, I'm saying.
30, my lord.
Ah.
30 I have already referred, my lord. Lordship will find at page 40. Lord. Yes, the charge sheet starts from 38 because the complaint, Lordship will kindly take a note that by an order dated 21/2023, that complaint petition dated 21/23 was referred to the police for registration. So there was no subsequent order of the learned court below after 21. But the in charge sheet says in clause number 16 at page 40, my lord. 16. Page 40, column number 16.
Yes.
The brief of the case is that on 18/2/2023 at 2:30 p.m., the complainant is Sanjay Jain, such and such, such and such, such and such, phone number, lodged an affair. Lodged an affair. So it was not referring to the complaint petition of 21/1/2023 before the complaint. So in the records, my lord, this complaint has been, that this complaint is missing. On the basis of which the police has commenced the investigation and filed the charge sheet. Neither there is an order of the learned court below, nor there is any reference. Now, if I'm placed before this court that this complaint petition, in fact, reached to the office, Dibrugarh PS on 18/2, and that was registered. So therefore, the OC says that on 18/2, he has received an FIR from the complainant. If I'm saying so. So it cannot be believable because the court says in the impugned order, that is the referring to the foolish dated 21/1/2003, forward the case report to the concerned OC for compliance. Bench assistant is to do the needful. So bench assistant is always to be expected that it is to be transmit the record immediately. So on 21/1/2023 itself, it has to be transmitted, or on the next day, or in all probabilities. But the case was registered on 18/2 because the page 30, that is the FIR, that says that the case was. Lordship, kindly have a look again on page 30. That the original FIR is enclosed herewith. It is said. And so therefore, on 18/2/23 itself, the case was registered. So therefore, in between this 21/23 to 18/2/2023, even if assuming, my lord, even if assuming that that complaint petition which was filed before the court, that was registered on 18 to 2023, on the basis of the direction of the Honorable Court, then in between 21-23 to 18 to 23, under whose custody that complaint was lying? Whether the complainant himself took the custody of this complaint, or there is something else. So there is a mystery which I am pointed out, but this is not my final argument, my lord. Because this I am pointed out to this because there is a situation created, there's a doubt created in the records. So this is my submission, but the submission to the legal submission, my lord, which I invited the attention of this court is that look, that the first complaint is that 12/9/2023. So you cannot improve that complaint by lodging a complaint by complaint, my lord. And if we treated that 12/9/2023 complaint as a FIR, all subsequents are statements. If lordship is kindly taken the T.T. Antony case or the Arnav Goswami's case, that all those statements, my lord, is a settled position of law, that all statements are to be treated as statement under section 160. It is hit by the 162. So it is to be treated as a statement under 161. So if 12/9/2023 statement is to be taken into consideration, then, my lord, that this is a allegation of defamation. So therefore, if it is an allegation of defamation, an independent FIR is not maintainable. Okay. This is number one, my lord. And secondly, and most importantly, my lord, I'm just reiterated, I'm sorry, that the entire complaints, if you take into consideration of the first complaint or the second or third complaint, my lord, that no individual participation of commission of any criminal offense, my lord, that not attributed to the petition's hearing. Because I must say, a general and omnibus allegation in the criminal case, my lord, cannot be stands. I must say that on such and such date, on such and such occasion, this person has committed this offense. So if it is cognizable, then the FIR to be registered. If it is non-cognizable, my lord, FIR cannot be registered. It is a non-FIR case and the police has to submit a charge sheet and ask for a permission from the court under section 155 of the CRPC for proceed further. So this is a situation. Now, lordship is, if a scrutinize and giving a plain reading of the complaint of 12/9/2022, it only concludes, my lord, that the allegation is a defamation. This would be the only logical conclusion. So therefore, I am pressed for a judgment, my lord, of the Honorable Supreme Court, 2020-14 SSC 12. Arnav Goswami. এইটো মই পঢ়ি দি দিম তোমাক। Yes, yes. Para 36 and page number 38, madam. Referring to the Honorable Supreme Court in this case, referring to a case of Babulal versus State of Gujarat. Kashyap has got it. Yeah. In such a case, the court has to examine the facts and circumstances giving rise to both the affairs. The test of sameness is to be applied to find out whether both the affairs relates to the same incident in respect of the same occurrence or in regard to the incidents which are two or more parts of the same transaction. If the answer is in the affirmative, the second affair is liable to be quashed. However, in case the contrary is proved, but the version of the second affair is different and they are in respect of the two different incidents. If there are two different incidents, my lord, then the second affair is maintainable. Otherwise also, my lord, if there is a counter affair, then that affair is maintainable, arising out of the same incident. So therefore, if there are two versions, my lord, then the second FIR is, if they are same version, then the second FIR cannot be maintained. In case the respect of the same incident, the accused in the first FIR comes forward with different version or counterclaim, investigation of both the FIR has to be conducted. This court held that the relevant inquiry is whether two or more affairs relates to the same incident or relates to incident which form part of the same transaction. If the court were to conclude in the affirmative, the subsequent affairs are liable to be quashed. However, for the subsequent affair relates to different incident or crimes or is in the form of the counterclaim, investigation and proceed. So Lordship is to kindly leave it to the Honorable Court, my lord, to see that the allegation made in the subsequent affair, which dated 21/1/2023, which relates to the same incident or different incident. If it is different, then it's maintainable. If it is same, my lord, then that has to be quashed, which we prayed before this honorable. So we cannot articulate, my lord, that the basic allegation is that we have, even assuming to be correct, even I have admitted is correct, my lord, the facts. Because Lordship is the Bhajanlal case says that you have to see the affair as is true and then you counter it. Now, if I am assuming that the affairs are correct and true versions, then what are the incident occurred arising out of? That is the Binoy Shah complaints. And they said, we prompted him to file the complaint, which he subsequently withdrew. And that complaint is circulated in the WhatsApp group. That's the incident. And that incident, my lord, has referred in 12-9 affair. So they also referred in the subsequent 21-1. So 21-23 cannot stand. That my submission on the basis of this law. Now, Lordship, kindly have a look at paragraph number 54 and 53. For 54 and 53, my lord. 53, my lord, I'm leaving to the Honorable Court to read later on, because I'm just to cut short the judicial time, my lord. The 54 is conclusion, my lord. But it starts from 53, whether this defamation, allegation of defamation, my lord, whether that can be treated to be an affair or not. Now, 54 is conclusion. Interpreting this provision, a two-judge bench of this court in Subramaniam Sami v. Union of India held that neither can an affair be filed nor can a direction be issued under section 156(3) CRPC, and is only a complaint which can be instituted by a person aggrieved. So far the defamation is concerned, my lord, neither the affair nor direction by 156(3). So if Lordship find, I leave it to the Honorable Court, if Lordship find that the basic allegation is of the complainant is tarnishing his image against these petitioners, then FIR cannot be. Then 156(3) cannot be. Only option is, my lord, that file a complaint, criminal complaint. With this, I leave it to this Honorable Court, my lord. My lordship will find the cognizance order. I leave it to the Honorable Court, my lord. No application of mine. No application. But in that event, lordship may set aside that cognizance order, revert back to again. But I am not on that, my lord. But I am only referring, my lord, if your lordship is find the cognizance order at page 42, dated 10/7/2024, in the my criminal petition, my lord. The court says this is a stereotype, my lord, consideration. Peruse documents. Lordship, kindly have a look for a minute.
42.
42. Peruse documents. What documents, my lord? What documents? Not a single document the court has perused, my lord. Because in the charge sheet, Lordship, kindly have a look at charge sheet. No documents has been annexed. What annexed, my lord? 41 notice. To the requiring. In cognizance order, Lordship will find upon perusal, charge sheet and other accompanying documents. In 42, my lord. Accompanying documents. What are the accompanying documents with the charge sheet, my lord? I just pointed out to the general court, my lord. Lordship will kindly have a look at page 41. It is expected, my lord, with all humility, that the learned trial court, while issuing a summons, my lord, to ask the person to face criminal prosecution, has to keep in mind the consequence of the summoning order. Pepsi, this judgment of the Honorable Supreme Court long before 1992, my lord. This again reiterated in this judgment, my lord, of this 2026 judgment, which we referred to. Now, Lordship will find in 41, list of enclosures, 4 copies of notice for 41 and CRPC. That was the inclusion, my lord, of the charge sheet. And Lade trial court says peruse documents. So with this, my lord, I conclude.
First, when it takes a complaint, first page, by first page, kind of matter of is salience against the search sheet. A complaint will be filed by my lawyer.
Yes.
This complaint petition has been filed against the search sheet file. I am reading, my lord, an application under section 528 read with section 12 of PNS paying for a crossing of the search sheet number showing so dated under the section submitted by the investigating officer in connection with the report PS case. This is the main fact. This series challenging here the search sheet file. Secondly, my lord, he has submitted some impugn order, my lord. First impugn order is the 21/1/2023, my lord, which has been passed by the learned judicial magistrate Dipurgarh in connection with the complaint petition filed by the respondent number 2. Now, my lord, question is that what my learned tribunal has submitted for your lordship about 2 FIR, my lord. That 2 FIR has not been registered by the no action has been taken by the police. Neither the police OC has been registered a case or taking any investigation was done. Nothing has been, no registration. Secondly, my lord, we have approached the superintendent of police.
Lord, I have another quote, my lord. May I be, my Mr. Decca is there.
Yes.
Madam.
So you're saying earlier 2 FIRs were not even raised.
Not been registered, my lord. First register lawsuit will find at page 21 of my IA, my lord. This is the written objection now. That has not been registered. My lord, I have made the statement, my lord.
21 of I.
My lord, my IA, my lord, 119.
Yes. Page 21. 21 page.
That is the page 21, annexure 3. In this regard, my lord, I have made the statement, my lord. Kindly peruse my statement, my lord. That is lordship will find at page 6, Roman 3.
Yes.
Yeah, Roman 3. That on 12/9/2022, the present applicant approached the Dipurgarh police station and submitted a complaint against the petitioner of the criminal petition number so pending before this honorable court. And the officer in charge of the Dipurgarh police station did not register a case on the basis of the complaint submitted by the application, nor any GD entry has been made. Nothing, my lord. This is the simple white paper. And
that after preliminary inquiry, the DGNT and was made and stating that after the preliminary inquiry, the case would have been registered. But for next 1 month, the officer in charge, Dibrugarh Police Station, neither inquired the matter nor registered any case on the basis of the complaint lodged by the present applicant. On that application, my lord, what complaint I have lodged before the officer in charge of the Dibrugarh Police Station, neither it has been registered nor it has been received copies was provided to us. Therefore, my lord, we have not taken it in our plea. And secondly, my lord, we have lodged the FIR complaint before the superintendent of police, my lord. My lord, this is not lodged by any advocate, my lord. This is lodged by my client. He is the layman, my lord. This complaint was acknowledged. Lordship will find at page 22. This complaint was acknowledged. Lordship will find in bottom in the seal of the superintendent. Again, my lord, remains same, my lord. It was where it has gone, my lord, we don't know, my lord. No case has been registered. Neither it has been sent to the proper police station for registration of the case or investigate the matter. Therefore, my lord, both the FIR, whatever he emphasizes very much in the long time, my lord, this is a meaningless, my lord, at this stage, my lord. And then, my lord, we have approached this court, my lord. We have approached the trial court, my lord. That is, lordship will find at page 23, my lord. Annex 5. That complaint we have filed before the court of the Chief Judicial Magistrate, and accordingly, this case was placed before the court on 21/1/2023. My lord, this is the order, my lord. He has made the impugn. My lord, 3 paragraph I am reading, my lord. Perusal the case record from there. From page 29 and Annex 3 of my IM.
Yes. Yes.
On perusal of the case record, it revealed that the allegation revealed in the instant case under section so and so. Therefore, under facts and circumstances, this court is of the opinion. My lord, these 3 words, my lord, are very important, my lord. Why important, my lord? I am coming with a reference to the Supreme Court later on, my lord. This court is of the opinion that the case should be investigated by the police under the actual fact. This paragraph is very important, my lord. Considering the entire aspect, the concerned OC is directed to investigate into the case by registering a case by treating the incident complaint petition as the FIR. That complaint petition may be treated as the FIR and register a case, and to investigate into the matter and to submit final form as early as possible. And accordingly, my lord, this case has been forwarded to the police, concerned police station, that is Dibrugarh Police Station. And my lord, after receiving that, my lord, this complaint, this order and the copy of the complaint petition, this complaint petition convert to the FIR, reach to the OC, Dibrugarh Police Station. And after receiving that, my lord, on 18 to 2022, as my senior friend has, learned senior has submitted, has filled up the form. After getting the all documents from the court, my lord, court has passed the order, and then, my lord, police got this information, and this form has been filled up. Prior to the order, my lord, police cannot register the case. After passing the order, my lord, when the copies has reached the police station, then police has registered a case on 18 to 2023. My lord. That
So
is
now what
lordship
will
will
be
find
the
at
question?
page 30.
Now, see, question is that this FIR has been registered on the basis of the complaint of 18.2.
18.2.
And your petition before complaint before the court was on 21/1/2020.
Yes, my.
Then?
No, 21/1/2023.
But that reference is not there in the FIR which has been registered by police.
Police, that is on 18/2/2023.
Then where is your complaint?
This
No,
complaint
my simple question is
this
that
lordship will find at
No, no,
page 33.
no, question is that simple. The FIR is the law instituted or instituted or the case has been registered on the FIR laws or the complaint laws on 18/2/2023. Whereas your complaint has been filed before the court and that has been passed on 21/1/2020.
Yes.
Where is that?
That complaint lordship in the file at page.
No, no, after court, when the court had passed the order that 156(3), it has to be sent to the Constant Police Station,
Yes,
on the basis of which case has been raised.
for that case is lordship, CR case number 10C 2023.
After 156(3). No, no, after 150,
Yes, my lord. I, my lord, what happened, my lord? I am coming to the very first beginning, my lord. We have two FIR, my lord. that have
earlier
been-
you said those were not registered.
Yes.
Yes.
Lastly, my lord, we have approached that court. Lordship will find at page 23 of the complaint petition. I have also annexed my 23 of the complaint petition filed by my.
Yes.
This is the case has been registered by the Court of the Chief Judicial Magistrate as CR case number 10C.
10C 2000, yes.
This is the complaint, my lord. This complaint has been detailed as the FIR for the order dated 21/2020.
Yes, yes, yes.
Thereafter, my lord, after passing this order, my lord, the documents has been sent from the court, not by me, my lord, from the court. And when police has received the copy from the court, my lord, they have registered the case after on 18/2/2020. First, my lord, 21 January, in the month of January, order has been passed, and 18/2/2023, my lord, the police has registered a case and started to investigate. And this FIR is annex here, my lord, and started from the 33, lord. 32, my lord. This is the form, my lord. First information from. Since that, my complaint has been sent to the police station for investigation and registered a case.
Just
That has been coming that. And after that, my lord, after state investigation,
now see your complaint before the CGM, which has been registered as CR 10 of the 10C 2023.
yes, ma'am.
That was sent before a police station for registration of case under 156.
Yes.
Now my question is that when the case is registered under which section down see?
The police has
Police state this registration was
police case,
paid
my
at-
lord, that
paid-
police case number, Dibrugarh PS case number,
and that is the
93.
page
lordship will find at page 30.
page zero. Here that is my question. But here if you see it is that 18/2/2023 on the basis of the complaint of 18/2/2023 that matter has been raised. Now where from 18/2 is there? Where is the 18/2/23?
18 my lord, that is here, my lord, clause number 3 of that page, my lord, ABC.
Hmm?
ABC, clause number 3 of the form of FIR, page 30. Clause 3, A, general, a diary reference so-and-so, occurrence of offense so-and-so, information received dated 18/2/2020.
That means you want to say that your
After
complaint,
passing this order.
yes, the order was passed on 21/1/2023. So from 21/1/2023, it took say near about 20, 26, 27 days to reach the police station.
My lord, it is up to the court and police to decide.
So what
They
you
are
want to say
communication
that
have
there
no
is
anything-
there any complaint, other complaint on 18/2/2023 that was Mr. Datta is submitting, that whether there is any other complaint on 18/2/2023?
No.
As per you, there is no such
No,
complaint.
not that. My lord, that is started from 32, page 32.
See?
Two. This is the form only, my lord. And the main case has been here, my lord. 32. Continue. This is the FIR now. My complaint. Where the 21/23 order has passed. No any case. And then, my lord, on the basis of that, my lord, police has investigated the matter.
So where is their statement? Now see, if you go by the 16, page 32, the column 16.
My lord, this is the affair, annexure 3 of the complaint taken. This is started from 30 and end with 37.
30.
30 to 37. This is the affair. After the passing the order by the CGF.
No. Still you're not following. What I'm asking, that understood the earlier two affairs were not registered, not entertained by police. So leave apart these two other. Now subsequently, when they have not registered, you approach the court with a petition that has been entertained and your request, whatever, that has been sent for registration of a case 156 and for investigation. Now your complaint and the order was passed on 21/01/2023.
Yes, ma'am.
But here repeatedly it is saying that on basis of the complaint of 18/2/23.
Yes.
Where from it is stated?
That I complain, madam. One complaint only. No other complaint. This is that. This
Then
is
why date is on 18/2/2023?
madam, that is up to the police, madam. They can say, madam. Put the communication, madam, of the court. The court official registry can say. Madam, why so many times has been taken, madam. After, my lord, as per the court order, that my complaint has been registered as the FIR police station case, Ipugo police station case, and madam investigate the matter, madam. And later on, my lord, the police said after the investigation, after conclusion of the investigation, my lord, police has submitted.
This is the page 30 is the final form or the charge sheet.
Yes.
Now where is the registration of the case? 28. Received on 18/2.
Yes. This is the
That's what I'm asking you, Mr. Kotakuri is doing that, because there has to be something, na? You are verbally are saying that you are not aware where it has come. It is received.
My court has
Only on
sent-
18.
My court has sent it today. CGM court, my lord, has sent it.
Obviously, CGM sent it. I'm just asking where from 18/2 has come.
Yes, ma'am.
The date of
Received
18/2.
and
That
registered
18/2
by Diplo
has
case
come as and when they have received the complaint.
18.
That is the case. Mr. Dekka, that is submitted by Mr. Datta that 18/2 complaint is there.
Yes.
There is no, sir. Why you have made such submission? There is no such complaint on 18/2.
Yes.
In fact,
Yes.
That is the complaint received by the police only on 18-2.
That is,
So your submission is there, then 18-2, another complaint was there, which is
no,
not in
that
the
is not
record.
his
And
submission.
it mentioned in the, it is in the charge sheet.
No, no,
That is not the case.
no, his submission was that in the remark column of the SARC,
Huh.
there is a mention that on 18 to receive the complaint.
18-2
Yes, Lord.
complaint.
Yes, Lord.
It is not a case, then 18-2 was, another complaint was there.
Yes,
It
no,
is the case,
there is no complaint.
as Mr. Bhattakur has pointed out,
Yes,
it
yes.
is the case on 18-2, the police received the complaint.
Police received the complaint.
Then why you are misleading the court that 18-2 there
Or
is
Mr.
another-
Perhaps he has not gone through
Just
that part.
asking
Yes.
repeatedly. Mr.
I have
Bhattakur, where is
also-
the complaint? Where is
I-
the complaint?
I am also gone through the.
Bhattakur has submitted. No, that is not the complaint. That is received by the.
Yes, Lord. So that is code has forwarded
You have
us.
made the submission that on 18-2 another complaint was there. Where is the complaint? No such complaint was
Perhaps
there.
he
Another
has.
complaint.
Perhaps he has. This gone through page 23. He has gone through properly. So therefore, he has perhaps made such statement. Otherwise, in the SARC also, in the SARC remark column, it is not stated that the complaint has been forwarded by the court, which has been received on 18-2. There is no such remark.
It is obvious. It is
Yes,
forwarded. only.
That time, madam, police has submitted the search sheet, madam.
Hmm.
Police has submitted the search sheet. After getting the search sheet, now, madam, I'm very much sorry, but kindly take I, madam, for the time being.
Hmm.
Police has submitted the search sheet. Search sheet logic will find at my I, page 30, annex 7.
Yes, yes, that is only.
That is the search sheet, madam. That search sheet has been after submitting of the search sheet. The court has registered the case as GR number 332 of the 2023 and PRC 307. And my lord, on 11/7/2024, my lord, the court has taken the cognizance and issue of summons. That is lordship I am reading. Case record is received.
In which page? Which page?
Page lordship will find at page 34 and extra 8
Hmm.
11/7/2020. I am reading.
Hmm.
Case record is received on transfer from Larner Chief Judicial Magistrate Dibrugarh for disposal. Peruse the case record along with the search sheet and other accompanying documents. Upon perusal, sufficient ground is found to proceed against the accused. Sri Ronil Pudda, Sri so and so, under section so and so, as such cognizance of the aforesaid offence is taken against the accused person. Issue summons to the accused. Hence, assistant issue text. Later, manner, summons has been served to the petitioner. And my
Here the cognizance was not taken against any section of defamation.
no defamation. The question of defamation is submission, my lord.
Acha.
On the basis of my first affair, which has no any existence, my lord. First and second, that is his submission, my lord. Defamation, the question of defamation does not arise. Question is the 120B criminal conspiracy, 200, 420, and 506. And my lord, cognizance has been taken. After that, my lord, turn to the next page, my lord, page 35. This is the order date. All order, my lord, summons has been served to them. Case has been fixed. They never appeared before the trial court. And then, next page, my lord, page 36. On 23rd, after getting the interim order from your lordship, from this honorable court, they submitted the interim order before the court. And then, my lord, and in the interim order, my lord, they have submitted before your lordship. My seniors, my learned senior has submitted very beginning about the paragraph 10 of lordship order. That is at page 43. He, on that day, my lord, while he has got the interim order, on that day, my lord, he has relied a judgment of the Honorable Supreme Court, Babu Venkatesh and others, the state of Karnataka. On that judgment, my lord, Supreme Court observed that our judgment was passed. Judgment was reported on in the year of 2020. That is 22/5/639. In that judgment, in the paragraph 30, it was observed that as the person approached the police authority, that the superior of the OC, that means superintendent of police, and then my lord, they can file the complaint petition before that. This is the check on the basis of that, my lord, and his allegation in the 21, but he has submitted, this is out of pleadings. What today he has submitted, this is totally out of pleading. His main pleading is that, madam, I have not properly followed the provisions of this
160 procedure. Yes.
Yes, Babu Venkatesh, this is important. Without following the Babu Venkatesh, that is section 154 of the PRPC. The court cannot take any, cannot take the observation of, cannot take the matter or register the case, complaint case, and cannot send it to the police for registering a case and investigate. But that is not. Now, my lord, Supreme Court, my lord, Supreme Court, on 4/11/2025, my lord, one judgment has been passed. On that judgment, my lord, same case, my lord, my lord. He knows the case, my lord, in the additional affidavit I have submitted. Only one judgment that is reported on 25 AIR SC 5486.
Yes.
My lord, this case, kindly first peruse the paragraph 9. There's no case no problem. Paragraph 9.
Para 9.
Paragraph 9. Same case, my lord. It is contended that all the agreements in solution with one another created and produced the force fabricated and manufactured document to obtain the favorable order and obtain the possession of the stood property and have also completed the recent receipt of the justifying their possession of the property. A complaint was also lodged with the Khadebazar police station, Balagavi, to inquire about the forgery and the of the document. Still no steps taken by the police on that stage complaint. Next, my lord, Terate, same to my case. The appellant later filed a private complaint before the JMF. To JMFC filed order details felt that the matter was to be referred for investigation under section 156(3) of the code. The JMFC referred the case for investigation to the Khadebazar police station. Accordingly, the first information report was registered against the accused number 1 to 20. And for hearing after referred as the affair for offenses punishable under section, same section 9, 120, 420, same section 9 of IPC. And investigation was undertaken. That under JMFC in the order to the complaint was complied with the direction of exclude by the court. And then, my lord, 11 is the, and thereafter, my lord, opposite party approached the High Court, passing that order and the proceeding. And High Court has passed the impugned order, my lord. That is that paragraph 11. That is short, my lord. High Court says that that cannot be done without following the section 154 of the TRP. That is the case. Same case, my lord. Police first approached the police station. Police doing nothing as my annexer 2 and 3, my lord. And then, my lord, he approached the JMFC. After perusal of the case, JMFC sent it to the case and investigate the matter. The question of the 154 does not arise now, till now. And then, my lord, can turn to directly, my lord, turn to paragraph 37.
Yes.
In this juncture, it would be aforesaid to refer the position of law enunciated in Madhav versus State of Maharashtra 2013 5 SCC 615, wherein it was held that when a magistrate received a complaint, he is not bound to take cognizance if the fact alleged in the complaint disclose the commission of an offense. The magistrate has discretion in the matter. If on the reading of the complaint, he finds that the allegation herein disclose a cognizable offense and the forwarding of the complaint to the police for investigation under section 156(3) will be conducive to justice and save the valuable time of the magistrate from being wasted of inquiry into a matter which was primarily the duty of the police to investigate. You will be justified in adopting that process as an alternative to take cognizance of the offenses itself. As said earlier, in the case of the complainant, regarding the commission of the cognizable offense, the power under section 156 can be invoked by the magistrate before take the cognizance of the offense under section 191A. However, if he wants to take such cognizance, the MR so and so, so and so, so and so. That my lord, court says, my lord, if court think it fit, that the 21 order, my lord, 21/1/2003, my lord, that paragraph, my lord, where court CGI clearly stated that he found something. Whatever it is correct or wrong, matter, that is another thing. It is the total power is conferred to the magistrate. If magistrate satisfied, yes, I have got something that should be registered. That should be investigated the police, that can be stayed. And now, my lord, paragraph 38, my lord, in there, my lord, 22(1. In reference to the Ramdev Food Products Private Limited case, my lord. There is the 22(1.
Yes.
The direction under section 156T is to be issued only after application of mind by the magistrate. When the magistrate does not take cognizance and does not find it necessary to postpone the issuance of process and find a case made out to the process here with direction under the state provision is issued. In other words, where on account of the credibility of information available or hearing the interest of justice, it is considered appropriate to straightway direct investigation. Such direction is true. And on the basis of that, my lord, what happened, my lord? Supreme Court says, my lord, Honorable Supreme Court says at page 43, my lord. Page 43. Okay, para 43. No. I'm reading. Thus, on the overall circumstances of the facts and circumstances of the case, the material on record and the submission made by the learned counsel for the party, first and second interim order, that is so and so are set aside. After crime number so and so Khadeboda police station, then resorted. The police is directed to investigate the case expeditiously and accordance with law. It goes without saying that the private parties shall be at liberty to produce materials to indicate their defense position during the police investigation, as also to the court concerned and accordance with law and appropriate states. And same case, my lord. Here, my lord, what happened, my lord? Still did not set aside this order, my lord. And I'm coming. That can be done. And that what he has submitted the check on the date in respect of the other affair, that affair has no existence. No existence. Since police has not accepted. Not registering the case means it is not accepted. And my lord, on the basis of the application, that can be done as per this judgment, my lord. That can be done, and properly the magistrate has passed the order dated 21 and sent it for the police station. And my lord, till that, my lord, that case, what he has submitted, he has silenced by this order as per of the petition, my lord, in the matter of the search sheet, my lord. Till that, my lord, no search has been framed, my lord. Only cognizance has been taken. They were not appeared till not a single date before the court, my lord. And my lord, they have submitted the Babu Venkatesh to get the interim order, my lord. That interim order is not maintainable at this stage, my lord. And the search sheet, my lord, on the basis of the searches, what he has to get submission passed, let them submit before the trial court, my lord. Why he directly come on the basis of the 21/1/2023 order, my lord. His entire petition lordship will find only this order, my lord. This content petition 154 is not followed, therefore, my lord, this case is not maintainable. This order is not maintainable. But now Supreme Court says, yes, it can be maintainable under section 156 of the CRTC. The magistrate has the ample power, if it is fit, that to investigate by the police and to save the time, unnecessary waste, send it to the police station for investigation, my lord. That is the case. Very simple, my lord. He has made so many subjects, the submission, my lord, who is not beyond the pleadings, my lord. In their petition, my lord, nothing was which find. Nothing, not a single word lawsuit will find. Now he trying to twist the matter to another direction. Another direction is applicable if both the FIR has been registered by the police. Police did not register any FIR, not a single FIR of my side has been registered. One I have mentioned in my complaint petition because that has been acknowledged. But first one not acknowledged, we cannot establish. For my advance my submission, my lord, I have annexed it. And second FIR before the police, before the superintendent of police of Tribunal, my lord, that has been acknowledged. That's why, my lord, I have made the statement, paragraph 7 of my affidavit of my complaint petition, that I have approached the police authority, but the police authority did not take any action on my affair, neither registered the case nor my lord investigate the matter. And then, my lord, alternative, my lord, we have approached the court, and on that day, my lord, we have paid before the court that my lord, this complaint petition may be treated as the affair and send it back to the proper police station to investigate the matter, and final form may be submitted. And accordingly, police have done it. And on the basis of the new order, judgment, what I have submitted, there is no wrong committed by the learned CGM Dibrugarh in passing the impugn order at lordship will find at my IA Annexure 629. This clearly stated that on perusal of the case record, it is revealed that the allegation level so and so, so and so, so and so. Therefore, under the facts and the circumstances, this court is of the opinion that the case should be investigated by the police to unearth the actual facts. When under section 156, empower the court to send it to police, and then, my lord, my learned friend cannot say it is wrong. And court has the power, my lord. Court satisfied, how he can say it is wrong satisfaction on the court. This court satisfaction of the court is not proper. How he can say, my lord? This is empowered by the statute of the land, my lord. Statute say, and Supreme Court, it is emphasis in the case, my lord, where 37 and 38 and my lord 43, my lord. It is totally covered my case, my lord. On the basis of that, my lord, I get the interim order and set aside this case. Let them appear before the court, my lord, and what he has submitted before your lordship, let them submit it. If court will not accept that his submission, with the revision, my lord. This now, my lord, his entire case has been, he is challenging the search sheet, but entire case based on the 21/1/2022. That complaint. This is the case, but only this judgment is the sufficient. Babu Venkatesh is nowhere. On the basis of the Babu Venkatesh, my lord, he is not entitled to get the entry amount of complete. That may be vacated. This is my submission.
Only in reply, my lord, I'm just clarified. While I'm submitting, my lord, in regarding 18.2, my submission is only confined to that, my lord, that on the basis of that 21/1/23, the case was registered. But my query, that was what stuck in my mind, my lord, that 21/1/23 and 18.2, so near to 1 month, where the complaint was. That was nothing in the record. Number one. Number two, in the charge sheet, the IO said that FIR was lodged on 18.2. That creates a confusion. It's not created confusion by us. That's my clarification. Now, what the judgment relied by my brother, my lord, he has not, I do not know whether he has read out the entire, all paragraphs. My lord, kindly see the paragraph 10 of that judgment. The learned magistrate exercised the power under section 156(3) in compliance with Priyanka Srivastava case. And the learned magistrate reflected. And therefore, the Supreme Court has not interfered. Paragraph 10, my lord, kindly have a look. Paragraph 10 is clear. Lordship is, so the learned magistrate has complied the direction issued by the Honorable Supreme Court in Priyanka Srivastava. Therefore, that order was not touched upon by the Honorable Supreme Court. Here, Lordship is fine. Now, the interesting question, if your Lordship has just reiterate, I'm sorry, my lord, that 156 subsection 3 says what? Says that the FIR you lodged before the police, that to be treated to be an FIR, not your petition. May I read, my lord? Just, I'm sorry, my lord, I'm just, because otherwise we have to, your Lordship is come to a wrong conclusion. 156(3) is not an independent power. What 156(3) says? Any person agree by a refusal on the part of an officer Champai police station. They said it is admitted part that the FIR was lodged before the police. Either it is acknowledge or not, but the fact remains that on 12/9/2022, they have lost the FIR, my lord. They have not referred it in their complaint. Now, what in SP's application also they are referred to that. Any person agree by refusal on part of officer in charge of police station to record the information referred in subsection 1, that is 151, may send the substance of such information. 154. May send the substance of such information in writing or by post to the superintendent of police. So 154(3) to be complied with. Now, Lordship will kindly look at 156(3). And in SP's complaint, my lord, I've already referred that in SP's complaint dated 10/10/2022, there was no reference of 54(1), that substance, that lodging of FIR before the officer in charge. Thereby, that they have not complied that part. Now, Lordship will find 156(3). Any magistrate empowered under section 190 may order such an investigation as above mentioned of cognizable offense. Now, Lordship, is the Priyanka Srivastava is clear that you have to 154(1) and 3 you have to comply with. Now, the learned court having a power after compliance of that to refer which complaint, my lord? That the earlier complaint, not a new complaint. So the registration on the basis of 21/1/2023's complaint is bad in law. That my submission. You have to register the FIR which is not registered by the police. So that FIR was not registered. Which FIR was registered, my lord? The complaint dated 21/1/2023, which is bad in law. This is my legal submission, my lord, for consideration of this one. And we have prayed for, my lord, my learned friend has only read out the cause title. We have prayed everything, the cognizance order, charge sheet, everything, yes, in the prayer.
Yeah, that is.
Yes, my lord. That, and in the 482 application, my lord, the law point, lordship, we can raise any time and any stage before conclusion of my argument.
Paragraph 9. Paragraph 9 of my letter. And 10. Both the paragraph 9. In the 9 minus Supreme Court says, first he has lodged an FIR before the police station, my lord, Khadeb Bazar police. And in the next paragraph, it says the JMFC. JMFC, we have filed press complaint, and that complaint has been registered. Very much clear, my lord, from this area.
You have to comply the Priyanka Srivastava. There's only one thing. Supreme Court neither says in any judgment that we overrule Priyanka Srivastava and Babu for 2022, my lord. Never say.
And here, my lord, why I am relying the paragraph 37 and 38. 37 and 38 are very much clear, right? 156(3), empower the magistrate to send it after his satisfaction. This is the case, my lord.
This is not a disputed question of law, my lord.
Yes, my lord. Whatever he has submitted in
That is not.
case.
I am not challenging 156(3) power of the magistrate. I am only saying before that you have to comply the Priyanka Srivastava. And in his judgment itself, the Supreme Court noticed that the Priyanka Srivastava judgment has been followed by the learned JMC.
Priyanka Srivastava versus state, that is just in the paragraph 10, my lord. I am reading that earlier, my lord. And the High Court impugned order is that, right? And the Supreme Court in the 37 and 38. Why there is so many observations has been made. But in the light of that Priyanka Srivastava judgment. And my lord, here lordship will find so many judgment, my lord. And in that judgment, after that judgment, my lord, 37 and 38 has been referred in the state judgment. On the end, accordingly, my lord, 43. Paragraph 43 restore all things, my lord, by observing all aspects of what Priyanka Srivastava said, the other things say, and then court has the Honorable Supreme Court come to the conclusion is that, my lord, if magistrate deem it fit to send to the police for investigate and register a case and investigate the matter, the magistrate has empowered under section 156, and that can be invoked by the learned litigant. That is it.
Let our High Court say so, my lord.
What are antique sub?
Who is one of the important witness in this case. Regarding law points, my lord, all those my learned friend has already argued, and regarding the, my lord, I would like to point out that FIR, it is 12/9/22. That regarding that FIR, whether he has mentioned the complaint petition or not, madam, I have gone for the relative complaint petition. And my learned senior has also stated the order of the trial court dated 21/1/23, whereby my learned trial court has directed the police to register the complaint as an FIR, madam. Regarding that aspect, I will have to see the judgment again in detail, but my lord, that law point, my lord, my learned, regarding that, my lord, regarding the FIR, my lord, I would like to say one thing about that here in this case, although initially FIR dated 12/9/22 was filed, but those FIRs were not acted upon. So, my lord, there was no separate, my lord, FIRs were registered on the basis of that. Those FIRs, my lord, FIR, and thereafter no investigation was carried on. So at present, my lord, only the complaint on the basis of the, and thereafter on the basis of the order of the trial court, this case is filed after investigation. And here in this case, my lord, I have pointed out my lord, trademark the statement of some of the witnesses, my lord. Regarding those facts, initially, my lord, entire dispute arises because of, my lord, all regarding a one institute, my lord, that is a society, my lord, Sri Vishwanath Marwari Datatko Osudani. What happened, my lord? Initially, one PA Bhimarsa has lost an FIR against respondent number 2, my lord, and thereafter that case was withdrawn. Only allegation is that all these accused persons overpowered him, and my lord forced him to file a, my lord, for the FIR against the present. Regarding that aspect, whatever statement has stated regarding those statements, I have taken and finding materials, ultimately police has filed search sheet against all those sections in pursuance to the order of the learned trial court decision. There are police search sheet. And regarding that aspect, that he has not mentioned, the learned friend has not mentioned about the 16 to 22. If that would have been mentioned there, then trial court would have been directed the complaint to register that case and all those aspects are not because there is no mention about that FIR, and there is no investigation by the police. So on the basis of the complaint, actually, police has as per the direction and trial court will continue with the investigation.
I'm thankful to the learned additional PP, my lord, the assisting this honorable court. But Lordship, from the record, I have not gone to because it's a part of the record. We are not supplied the copies also. But so far the charge sheet is concerned, Lordship will find and taking to note that the basic that all WhatsApp messages that circulated, all those were not neither seized nor nothing has nothing has been happened, my lord. All those WhatsApp messages, which are a form part of the acquisition against me. There is nothing in the charge sheet. Only those are 41A notice. That's the, and there's the entire, Lordship may take a call, or Lordship is kindly considered. This is a very important aspect also, that whether the learned code under 156(3), this is a consideration point, my lord. I also asked to this honorable court, because that point is also gray, my lord, it's not answered properly. That 156(3), well, the learned court will ask the police to investigate. Then on the basis of which complaint? Is it the complaint earlier filed or the complaint filed before the court? That gray area, my lord. I'm only requesting this honorable court to kindly consider that as well. And my humble consider what I understood, my lord, my first complaint regarding the subject matter, that to be treated, the court will direct the officer in charge to register. You failed to register. You did not comply the Lolita Kumari case. So please register that FIR. What I am understood. I leave it to this honorable court.
What will be the fate of the complaint which has been filed before the court concerned?
That is an allegation saying that the authority has not registered the case. So I cannot improve. What I am saying, I cannot improve step by step. If I am improved, my lord, because the learned lower court, while taking cognizance, lordship kindly have a look. Section 200, 420, learned court has taken a cognizance. Section 200, 420, how application of mine? Section 200 is whether the IPC section is saying to be penal section 200 and 420, there is no allegation. CR case, my lord, there is in 190, my lord. 190, lordship is aware. In 190, if a complaint case is filed before the police, before the magistrate, the magistrate having a three option. One, it may dismiss it under 203. It may register a complaint case or may send it to the police for investigation. But here, this is not an independent complaint, my lord. What I am saying, this is not a first independent complaint. This is a 190 says, if I am putting in an independent complaint, my submission is, lordship, I'm just carving out this difference. My contention is that this is not independent. It is arising out of my first complaint before the police and superintendent of police. So my duty is under section 210, because the complainant rightly prayed for before the court. Under section 210, if something is pending before the police, then I have to call for a report from the police, whether you register a case or not. If not registered, then I having a magistrate having a power to direct to register. So therefore, the High Court has not exercised the power, my lord, to direct the officers in charge of the superintendent to register a case. High Court says to go for a jurisdictional court acts. So therefore, their grievance is my complaint before the police was not registered. They have not taken a cognizance of this. So moment the court will say that is registered the same. This is my submission. We will not take much more time. They have the say. We shall leave it to them.
What he has submitted, my lord, in the complaint petition, my lord.
Sometimes happen in the court.
Paragraph 7, my lord.
What has happened when suppose the 2-3 complaints has been made, it is not acted up.
Right.
In that case, the concerned petitioner can approach the trial court below with a request that has been that what had done by the police, just call for a report. In that case, the court has the power to call for a report.
Under
from
section
police
210.
station. Yes, what is
Correct.
the stage of the case or what had happened.
Correct, ma'am.
But here, one complaint has been lodged most probably. Yes. What?
No, I have clearly stated in paragraph 7 of my complaint petition that, my lord, on 10/10/2022, my lord, I have lodged a complaint before the police.
Police has not taken any action. Correct.
That has not what my DP has submitted. My lord, that has not been taken. It has no, my friend. On the basis of the complaint petition, on that, that's when I have denied. And that's why, my lord, on the basis of that, my lord, lordship may vacate the stay order. Despite all things, and let them appear before the trial court. What he has submitted before your lordship, that should be submitted at the time of the framing of charge for the trial court.
Okay.
I know that. I know. Don't give me an advice.
That is
To me, repeat for a second. I am repeat for my day. I never repeated anything. I'm repeat কইলো কোটো খুঁটি লওঁ.
Okay, will be bust.
Get full.
Please. No, এরপর শুনো এটা যে আছে কি number. Yes, see, will be 13 to keep hearing to you. No, leave petition to hearing of that. Oh. You, yes, Mr. Sheikh, you are appearing in.
My lord, at page
No, you are appearing on item number 13.
16.
16, my
You
lord.
cannot taking. I'm saying item number 13, you are appearing. No.
13.
You want to
My lord,
submit anything? What
item
the law
number
says?
16, my lord. Only record is to be called for, my lord. My client is in jail for 3 months, my lord. That is,
No, we
my
don't
lord,
have
only 4 years conviction, my lord.
13 to
Notice
keep,
is to
13
go
to
and
keep.
LCR is to be called for, my lord.
Yes, Botakur in item number 13 you have received. This is a leave petition, I think.
No, NI.
Oh, it is a NI. Notice is already
Lordship,
there.
actually, the last time the matter came up for motion in court 8, I had perhaps made a submission that notice may be issued to the respondents. Perhaps due to some miscommunication, it was not passed on to Mr. Justice Parthiv Jyoti Saikia. Lordship, the notice was not issued, so kindly an order may be passed that notice may be issued and steps may be, so that I can take steps.
You are Mr.
8th of the Lord.
Etal. Hard Mr. Etal petition. I have to take. Criminal petition 6 to the hour. So issue notice. Issue notice to the respondents to register to special dispute post and regular process. No formal notice is to be served on the state response number. However, copy of the petition may be served during the course. Let's say matter after 2 weeks will do. It has
Deeply obliged.
after 2 weeks listing as on a date. Yes, what is the matter?
May I please your lordship? Here,
14 you have to take a date, I think. I'm not going to hear.
then your lordship, can I make a prayer, lordship?
Yes.
This matter is fixed in the court below on 25th for argument. We may take one date, then if your lordship can kindly fix it on 27 or on 31. 31.
31,
On
30, 31.
Next week Tuesday.
30.
Next week Tuesday will be 31.
31 or first month, first April.
No. The 1st April, I am not there. Make it on 2nd April then.
2nd April.
2nd April.
2nd April, lordship.
Mr. Ullah is for respondent number 2.
I am for the petitioner.
Heard Mr. Aforesaid, Learned Counsel for the petition. And also heard you are Mr. B. Sinha, you are appealing for whom?
For all
Is for respondent number 3 to 6.
3, 4, 5,
5
3, 4, 5, 6. And also heard Mr. D. Utla, the Learned Counsel appealing for the Learned amicus, you are Learned amicus appealing for the respondent number 1. Also heard Mr. P. Water, the Learned Education PP appealing for the state respondent. The positive the matter could be taken. You're saying first.
May I make one prayer, lordship, because we have made a lot of effort to make the hearing. Issue is very small, lordship.
On
So-
the
So it
second
will
or
take.
third April.
Third will be
Third is the holiday.
second April.
2nd April.
2nd April.
2nd April.
2nd April, lordship.
How about
Still 2nd.
Diplomat.
Yes. What
Let's
is-
please your lordship.
Yes.
I have filed a statutory appeal, lordship, against the conviction of the petitioners for the offence under section 140, 61 and 115.
Your appeal is not admitted till.
Not admitted, lordship.
It's a statutory appeal.
Statutory appeal, lordship.
Yes, Botakur can be admitted.
Yes.
I is for suspension.
I is for suspension 2 years conviction, lordship. The order is the last page at IA for 26, lordship. 25 and 26, the orders. A1 to A7 are convicted under 115 and sentenced to suffer simple imprisonment for 1 month. A1 to A7 are further sentenced to simple imprisonment for 2 years for 140 subsection 3 and a fine of 5,000. A1 to A7 are further sentenced to SI for 2 years for offense under section 61 BNSS. And in the last paragraph, all sentences shall run concurrently. We are on bail. So previous bail, we may be allowed to remain on previous bail.
Counsel for the appellate. Mr. Is there any, only state is there, no? I think.
State is there also.
Mr. P. Waterford, United Edition. Then appeal under section 415, section 2, BNSS against the judgment and order dated 20/01/2026. Passed by learned session Judge Chiram in sessions case number 20 of 2025, convicting the accused appellant so and so, and sentenced to appeal is admitted for the TCM is the matter immediately on receipt of the TCM. And IA to become IA will be list after. Yes, I would support order report to list the matter accordingly, along with the connected appeal immediately on receipt of the TCM.
I may be disposed of. We should 2 years only sentence, Lord. Otherwise, we are on bail, we may be allowed to remain on previous bail, Lord.
Not finding it. How many weeks now they have it? 1 month, more than 1 month.
No, they are not in jail, Lordship. They are on bail.
They are in bail.
They are on bail, Lordship. Last 20th, 19 was date fixed, Lordship. On mentioning that date is fixed on 23, court has allowed us to bring the stay order, Lordship. 7 days time has been given to us, Lord.
Yes, do you want to submit anything? Are you on previous bill?
We are on previous bill, Lord.
I had to difficult, right? Mr. S.K. Buddha, Iran counsel for the petitioner, also had Mr. P. Waterford, Iran additional PP on this is an application and section 430 BNSS for suspension of sentence to allow the petitioner to remain on previous bail during the pendency of it. It is submitted by Mr. Buddha that by all judgment and order dated so and so 20/01/2026, the learned session Judge Chiram in sessions case number 20 of 2025 had convicted. He submitted that petitioner is still in previous bail, accordingly paid for allowing him to remain on previous bail till disposal of the connected appeal by suspending the sentence imposed on him while the said judgment tested. Next, Mr. Water, additional people, there is no objection that in view of this, the present interlocutory next paragraph will be hereby allowed. And the petitioner is applicant is hereby allowed to remain on its previous bail till the disposal of the connected appeal. And the order of the sentence, order and sentence passed in the judgment be stayed or be suspended till the disposal. With the above observation, the IS
Oblige, deeply.
16, what you are submitting, Mr. Sheikh? Yes.
May it please your lordship. This appeal is against judgment dated 8/1/2026, and there is a IA also for bail. And
Why
at this
admission hearing, Mr. Botak?
Case is not admitted.
not admitted yet.
Admitted.
POSCO is there.
Oh, POCSO is also there. Oh, oh, POCSO is
Notice should come.
notice. Should go.
That's the we will call.
Heard Mr. Amishi, Ilanit also heard Mr. P. Waterford, Ilanit additional PP, appeared of this case on This is an appeal under section 415 BNSS against the judgment and order of conviction dated 8/01/2026 by Special Judge Morigao in POCSO case number 75 public 2020, whereby the appellant was convicted in section 8 of the POCSO Act, read with section 354D/354 IPC, and sentenced him to undergo RI for a period of 4 years and also paid fine of rupees 5,000. In default, SI for 1 month. Appeal is accordingly admitted. Issue notice to the respondent number 2 through speed post and usual process. Also called for the DCR. However, no formal notice is required to be served on the state respondent number 1. Requisite copy may be served during the course. List accordingly. List immediately after receipt of the DCR. Okay, we are calling for the case record.
Notice for the IA may also be issued.
This later on will let them appear. Okay.
70. Much obliged.
May it please the Lordship. Lordship, this is a appeal against conviction, my lord. Convicted for 6 months, my lord, under section 354D, statutory appeal, my lord. May I pray, my lord, appeal may be admitted, my lord. My lord may call for the reports, my lord. There is an IA also, my lord. We are on a previous bail, my lord. Conviction was for 6 months, so I am praying.
I have some issues. I don't want to pass any order.
70.
You are Mr.
R.H. Chaudhary.
Your name is not there?
My name is not there, my lord. I've been instructed, my
Mr.
lord.
R.H. Chaudhary, appearing on behalf of Mr. The learned counsel for the appellant, and also for Mr. P. Border, the learned additional PP, appearing on behalf of the appellant. This is an appeal under section 415 BNSS against the judgment and order dated 20/01/26 passed by learned additional session judge, some special judge. So, POCSO Nagaon in special POCSO case number 04 N /2024. Appeal is admitted. It is admitted. Issue notice. However, no formal notice is required to be sent on state respondent number 1. All for DTC. List the matter immediately on the conviction term was how much?
6 months, madam.
Otherwise, also you are on previous bail, I think.
I am on previous bail, madam. That may be.
They are not passing any order. I don't have time.
Because on the next date is fixed on 18/4, madam. You were asked to produce
18/4.
18/4.
Okay, then 31st of this month.
Yeah, for the IA, madam.
For the I.
For the IA.
31st of Yes, what is 18?
This is criminal petition, passing of the proceeding.
Oh, due to positive, heard Mr. Diulla, the learned counsel for the also heard Mr. S. Nawaz, the learned amicus, appearing for the respondent number, and also heard Mr. P. Porter, the learned additional PP, appearing on the due to positive time, the matter cannot be. You want any fixed date here? Because many matters are there on 1st of April. 1. No. There are some matters in orders column. They will be left.
Item 31, my lord, bail petition, bail, IA for bail was there, my lord. Fix it on Thursday, my lord. Thursday, my lord.
Thursday, this week cannot be possible, not at all possible.
Monday, my lord.
If any interim is there, Mr. Borua will do that, otherwise no date.